Welcome to a Legalbytes presentation of the Karen Reed murder trial. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel we make sense of the law one bite at a time. If you want more on the background of the Karen Reed case, check out our video on it linked in the description below. But otherwise, you be the jury. Did Karen Reed murder her Boston PD boyfriend John O'Keefe, or is she being framed by local police who Reed says are actually responsible for O'Keefe's death? Tell us what you think. But in the process, the one rule is don't be a dingus. Remember, everyone comes from their own perspective and opinion, and everyone comes to conclusions at their own pace. Agree or disagree, but always respectfully. Okay, let's get into it. All right, you guys, we are back for the afternoon session. We are definitely starting late, but I needed that little bit of a break to get some food, get some water, all the things. So we are back now for the afternoon session. Like I said, the witness that we have on the stand right now is Ian Whiffin. He works for Legalbytes, and so he is going into the 2:27 a.m. entry from the Legalbytes report. What that means, he testifies that this is not the time when she searched for Hoslong to die in the cold. So he's going through that basically pretty methodically. There's a lot of people that have a lot of confusion about this testimony, and the thing is, if you guys are confused, the jury may also be confused. So it may not be, to me, it makes sense. I understand what the prosecution witnesses are saying. I actually agree with them from what I understand from what they've explained. Like I said before, I've had the ability to pause, replay, go back and rewatch things. So that's where I feel pretty confident in this stuff. But if I didn't have that ability, I probably would be pretty confused myself. So there is a bit here going on. We are going to go right back in to the testimony now that we are post lunch, and we're going to take it like we always do. Andy the Game Maker, thanks so much for the super chat, brother. I reserve the right to be a dingus. Well, you are the chief dingus of the channel. That's true. This is very true. Anyhow, thanks for the super chat. Questions in the chat, I will be tracking to save them and answer as many as possible. And that's about it. If you guys are enjoying the channel, you're enjoying the content, be sure to hit the like button. It really does help us. It definitely does. And yeah, okay, great. Let's get into it. First, maybe pull it on the screen. We know how to do this, right? Okay.
Okay, whenever you're ready, Mr. Lally.
You are, may I approach?
Yes.
We're still at 1.25, right? No, we're at normal.
Thank you.
I do, yes.
What do you recognize that?
This is the entire Google URL that was found on the browser state record. So broken down into each of its important sections.
May I approach, Andrew?
Yes.
Almost 62 minutes of exhibit.
Okay.
Same objection as before.
Okay, there are a couple of different objections. I need to see. I don't know what you're talking about.
Okay, sidebar right off the bat.
Yes.
Thank you.
Publish it for the jury.
Yes.
Now, Mr. Whiffin, what's up on the screen now, is that what you have before you at 618?
It is, yes.
And if you could, again, using a laser pointer, direct the jury's attention to what are we looking at in this 618?
Okay, so the left side of the table is the entire URL that was recovered from the browser state record. What I've done is broken it down into each of its individual components and explained what each of those components means. So the very first row is google.com/search. That just tells the browser that we're going to the Google website and that we want to run a search. The second part, the Q equals, is telling the browser what the query term is. So the query term here is Hoslong to dying cold. The little plus symbols in between is in place of a space because spaces can't be part of a URL. Next, we have the input encoding and the output encoding. Just explains what kind of characters to use and what language to use when you're accepting the search query and giving it back to the user. And finally, the important part is the and client equals Safari. This is something that just tells Google that this query is being done using the Safari client. Again, if I was to use Safari and just visit the Google web page and type that in, or type a search in, that part of the string wouldn't be there. That's only there because I used the Safari search bar as part of the Safari application to do that search.
Thanks. So Ms. Gilman, you can take that now. Now, sir, with reference to that, what, if any, relationship does that have to the information you were discussing just prior to it?
Again, that confirms that this search was conducted via the Safari search bar feature that's part of the Safari browser application, the same one that caused the records to be recorded in the plist.
Your Honor, may I approach the witness again?
Yes.
Dr. Who 8675309 and stuff would suffice. See, this is a real expert. This is what expert testimony actually looks like.
Another document. Do you recognize that, sir?
I do, yes.
And what do you recognize that?
This is the live records from the browser state.db database.
May I approach, Your Honor?
Yes.
I'm also seeking to introduce the witness. No objection.
Right, thank you.
May I return to the witness?
Thank you.
May you publish that for the jury as well, Your Honor?
Yes.
And Mr. Whiffin, do you recognize what's up on the screen now is what you have before you as Exhibit 619?
I do, yes.
Now, turning back to the browser DB database for this particular device, with regard to the timestamp and the last view time, what, if anything, do you observe in reference to that depicted in this, and could you direct the jury's attention to it?
Yeah, so this timestamp is the last viewed time according to the database itself. It's already been offset so that it's in local time. This particular table, we can see there are records missing. Between records 4025 and 4031, we have, 4025 and 4031, we have 4026, 27, 28, 29, and 30 missing. And typically the timestamps that we do have here, some of them are separated by as little as a second or two.
Now, with reference to the House Long to Die in Cold, that was record 4028, is that correct?
That's correct.
And so based on the records missing from this portion of the phone as far as that database, what, if anything, did you endeavor to do with respect to ascertaining one?
So first of all, the task was to try to recover the deleted messages. The deleted history records from browser state. So first of all, I was reading the deleted pages, essentially, to find the records that had been deleted from this current version of the page.
May I approach you, Your Honor?
Yes.
I'm sure we have another document. Ask you to that up in the finish.
Salamons, thank you so much for becoming a YouTube member. Welcome to Bike Club. Very happy to have you here. Thanks so much for supporting the channel. You're helping the.
And do you recognize that document, sir?
I do, yes.
So what do you recognize that to be?
This is the same data source, so it's still browser state.
Last term that you use, what does that mean? I'm sorry.
So typically there can be lots of different versions of a page within a WAL file.
Okay.
So you may have several page ones, several page twos, and so on. What I looked at is doing is recovering the data where the records that I recover are different from each other. So if I recover the same record multiple times, I can ignore it. But if I recover the same record with a slight change, then I would show it in this view.
May I approach, Your Honor?
Yes.
I'll seek to introduce in a minute. No objection.
Okay.
Your Honor, with court permission, may I publish after the jury?
Yes.
Again, Mr. Whiffin, if you could, please raise a pointer to find it helpful, direct the jury's attention to what are we looking at here and what, if anything, did you uncover during this portion of your analysis?
Yes. So again, the very first column on the left is the unique identifying number. You'll notice that there are some numbers here which are repeated. This is, as I said, because the records are recovered from multiple versions of the same page. There was actually 16 versions of this record across 23 different versions of this particular page. These three had some difference. Primarily, it was what's called the tab order field, but that's the only difference that showed up across these three Long to Die in the Cold records. All the rest show the same URL, the same ID number at the beginning, or tab ID number, and the same timestamp. Worth noting, there is no title shown in this particular record. Again, that speaks to the fact that this page didn't successfully complete loading. Otherwise, there would be a title of Google search, Long to Die in the Cold, as you saw on some of the other examples earlier.
Now, sir, with respect to the table up here, is there any indication in regard to private browsing that you were talking about before?
No, in iOS 15, as I mentioned, if you are using private browsing mode, there is no records recorded in this database at all.
So the fact that that's not listed in this table, what, if anything, does that tell you?
Everything that was recorded in this database was conducted not in private browsing mode.
Now, with respect to your work within your field, are you familiar with a term called a session?
Yes.
And can you explain to the jury what you want to understand that term to mean and how it applies to this specific instance?
Essentially, the life of the particular tab. So when I start a tab and I start to use navigation, I go to different websites. All of my navigation events would be considered part of the same browsing session, essentially.
Now, sir, if I could turn your attention to the Knowledge C database for a moment. And again, if you could, maybe I'm repeating this, as far as, can you explain to the jury what you understand that term to mean as far as what is the Knowledge C database in respect to the other databases you've been talking about?
Yeah, so far, the bulk of what we've discussed, the history.db, the browser state DB, and mobile Safari.plist are all particular to the Safari application on iOS. Knowledge C is much more global. It's much more ingrained within iOS. Everything is essentially recorded in there on iOS 15. So again, backlight activity, unlock activity, application state activity, and web usage activity is all recorded as part of Knowledge C.
May I approach you, Your Honor?
Yes.
Sure. Another document, we can just review that. Finish.
Yes,
And do you recognize that document, sir?
I do, yes.
What do you recognize that?
This is a document I created based on the Knowledge C web usage records.
May I approach, Your Honor?
Yes.
I'm off the seat to introduce and no objection.
Thank you. Thank you.
Thank you.
Your Honor, with the court's permission, may we publish that to the jury?
Yes.
Sir, again, what's up on the screen, do you recognize that as what's before you as the next exhibit?
I do, yes.
And if you could, again, Ms. Gilman, if I could ask you to scroll down to the green tabs. Thank you. Now, if you could, sir, again, using that laser pointer, if you could direct the jury's, well, first, can I ask you, what is it that we're looking at in this exhibit?
Okay, this is a particular, what's called a stream within Knowledge C. A stream is basically all like information being grouped together. So in this particular case, the stream is related to Safari. And it's telling us what web page was visible on screen, what time it started and what time it finished.
Now, with respect to this particular tab, there are portions that are highlighted in green and portions that are highlighted in blue. Is that correct?
Correct.
Can you explain to the jury what the portions highlighted in green represent?
I highlighted the sections in green due to their timestamp. So typically these items last between 2:27:37 a.m. and 2:27:53 a.m. So around the time of the Google search, if you were to believe the browser state.
And with respect to the items highlighted in blue, what if any? What are those?
The ones in blue are the actual Knowledge C records that show when the How Long to Die in the Cold and the How Long to Die in the Cont'd web pages were actually visible on screen.
And so from this, what, if anything, were you able to ascertain as to the searches or the time associated with the searches from your analysis here?
At 2:27:40, the only websites that were visible on screen were related to Ozone Basketball and Hockomock Sports, and that the How Long to Die in the Cont'd first appeared on screen at 6:23:56, and How Long to Die in Cold first appeared on the screen at 10:33 a.m.
So those two searches from your review of this extraction in this device never appeared on the screen prior to 6:23 in the morning, correct?
Correct.
Now, from all this, sir, what, if anything, were you able to conclude with regard to these searches?
So essentially, ignoring the browser state timestamp is important because that is not a reliable timestamp to show when that URL was visited. We have mobile Safari.plist record searches that show 6:23 and 6:24, and we show the same searches with very similar timestamps within half a second as showing up on screen in Knowledge C for the How Long to Die in the Cont'd, and the How Long to Die in the Cold was actually several hours later, which took a little bit more explaining, looking at Knowledge C and when the applications were opened up.
Now, with respect to your view of the extraction of the device around these times, were you able to ascertain as to what time this particular device connected to a Wi-Fi sometime after 2 a.m.?
I actually didn't look at any Wi-Fi connection information.
And with respect to 2:27 in the morning, 2:27 a.m., what were the websites that the device had visible, and what were the websites the device was connected to at that time?
So according to the Knowledge C records, which were mostly also reflected within the history DB as well, it was the Hockomock Sports, YouTube, Ozone Basketball, and that's it for the main domains.
Now, with regard to the Wi-Fi connection, is your memory exhausted as it pertains to that?
Yeah, I don't remember looking at Wi-Fi history.
May I approach?
Yes.
I'm showing you a copy of your report.
Thank you.
Review that and look up on information.
Okay.
And sir, I'm sorry. In the interest of time, if I could ask you just to look at the next page as well, just briefly.
Yes.
From your review of the extraction report in regard to this device of Mr. Case, about what time was the connected to a Wi-Fi network called in the case?
I believe it was 02:07. I didn't actually remember the timestamp just then.
And with respect to the disconnection from that, do you know when that was?
I can't recall.
Your Honor, if I may approach? Yes. I mean, in the interest of time, Your Honor, may the witness.
Yes.
Thank you.
Sir, if you can
Okay. The Wi-Fi was connected.
just indicate to the jury as far as the Wi-Fi connections with.
Okay. The Wi-Fi was connected at 02:12 and disconnected at 05:39. There was no further Wi-Fi activity until 11 a.m.
Thank you, sir. May I approach just retrieve, Your Honor?
Yes.
Now, sir, are you familiar with something called a write-ahead log or a wall file?
I am, yes.
And if you could explain to the jury what your understanding of that term is and how it applies in this specific case.
Yes. So a write-ahead log is essentially a temporary store for database pages. When I'm talking about database pages, it's not something that the user ever sees. It's part of the structure of SQLite databases.
Sorry, let me go back really quick because this definition of what a write-ahead log is essential so that you can understand what these people are talking about in terms of like this getting to the bottom of this 2:27 a.m. Entry log. So let me go back just to the beginning of his response here to the question. What is a write-ahead log? Listen carefully for it in case you guys are confused as to this whole thing. This is something, like I said, it's very important to understand what this is.
Term is and how it applies in this specific case.
Yes. So a write-ahead log is essentially a temporary store for database pages. When I'm talking about database pages, it's not something that the user ever sees. It's part of the structure of SQLite databases. Just as chapters in a book can span multiple pages, data in a database can span multiple pages also, and it's not necessarily in the expected order. It's up to the database application to find those pages and order them correctly in order to display the data to the user. The WAL file, on the other hand, it still contains pages, but they're organized in frames, essentially. And a frame is the same as a page, but with additional information at the top that identifies what page it is. So I mentioned earlier that it's possible to have multiple versions of the same page within the WAL file. That's because every time I write a record to the database, a new frame is created and the page is updated. So for example, if I was to have a new database, create a record, a new frame is created with page 1, and it adds my record. As soon as I add a second record to that database, a new frame is created again. So I now have frame 1 and frame 2. Both of those frames would contain a version of page 1. The first frame would contain only record 1. The second frame would contain records 1 and 2, and so on. Forensically, where it gets interesting is on the edit or deletion of a record, because the same process is applied. So now a new frame is created. The page number is the same as previously, so we'd still have a page 1. But now only the records that I don't want to delete are copied across. So I could end up in a situation where I have 4 versions of page 1. One has record 1, one has records 1 and 2, one has records 1, 2, and 3. But the most recent version of the page only has record 1 and 3, for example. Now, a normal piece of database software will only look for the most recent version of the page, so you would only see records 1 and 3. The forensic software can look at all previous versions of the page as well, and that's how we're able to recover record 2 in that instance. And that's
I'm going to cut him off really quick because when he was going to give this definition, I did not anticipate him going this far. I will say that in my opinion, the definition that was provided by Jessica Hyde, the other expert who testified about this stuff, I think that her explanation was much better for a lay witness. He's kind of going like really deep into the weeds here. And, you know, I feel like I had a pretty good understanding from it, like after really, really reviewing her testimony. And now I'm not sure where he is now. I'm a little lost in the weeds here. So this is also where, you know, when it comes to experts, the questioning really matters. Asking a question, making sure that the answer provided is good enough that the jury can understand it, not being experts themselves. But, you know, you've got to break it down so that he's been going on for quite a while in this definition. And I don't know what he's talking about with pages and frames and things like that. That was not, you know, anything that was sort of touched on by the last witness. I'm probably going to have to go back over this at some point and like to actually understand what he's talking about. So, and I'm really, really trying to understand this. My understanding of what a write-ahead log basically is it's a temporary space before that information gets permanently committed to a permanent space. And what Jessica Hyde did was she compared it to the permanent space being like an Excel spreadsheet where you've got data that goes into a specific slot, right? A specific box. But a write-ahead log is more like a big white text file where stuff is just kind of like written on the screen. And that you know, it until it's committed, it's kind of hanging out in that white space. And so to me, when she explained it that way, it kind of made me think of like when I have a random thought when I'm in the middle of a task and I have a random thought for something that I need to do later, or something like, you know, either a reminder for a task I need to do or something that has to be calendared or an idea for a video. I'm going to jot it really quick on my whiteboard. Or when people are like, hey, you should look into this particular case to do for like a classic trial or something. And I just scribble it onto the whiteboard. It's to get the thought there before it disappears from my brain. And then when I eventually want to go back and organize things into a list of like, what kind of topics do I want to cover later? Or, you know, what do I have on my to-do list? I'm going to go back to the whiteboard to sort of help me help me remember some things as I'm creating that formalized list. That's the permanent database, taking it from the whiteboard and putting it into a formalized list. And so then I can erase it from the whiteboard. So that's my understanding of a write-ahead log versus a permanent database. I hope that makes sense. But now here with this stuff, like I basically I'm a little bit lost in what he's talking about here. And I wish that Lally would interrupt him to help to redirect where he needs to go so that people can actually understand and follow along with what he's talking about, because he's getting very detailed. And even with a basic background understanding of what they're talking about, I'm not understanding this. And that's a problem for the jury.
Essentially how we were able to recover the browser state record from WAL.
Now, so turning to that issue as far as deletion, what, if anything, let me ask you this first, just before we leave the WAL file. So with regard to the WAL file, what, if any, relevance is there that certain data only exists within the WAL file?
So again, if I create a record that's in the WAL and delete it before it gets committed, which means when it gets merged into the main database, then it exists only in the WAL. It could be that it's a brand new record that just hasn't been written yet, or it could be one which was deleted from the database prior to the commit occurring.
When you say commit, what exactly is, what does that mean?
Commit's a process where essentially the database looks at all of the most recent versions of each page in the WAL file, copies them out from WAL and puts it into the main database, and then deletes the WAL file altogether. So at that point, we lose the ability to recover data from WAL because the WAL doesn't exist, but we have all the most recent versions of the page.
So that, if I understand him correctly, that's like the metaphor that I used about putting stuff on, jotting things down on a whiteboard and then putting it into a formalized list. It's like, as soon as I put it into the list, that's the committing action, and then it erases from the whiteboard. That's, if you're following that metaphor, that's what he's talking about by committing it into like the permanent space.
So turning to the concept or the topic of deletion of data, what, if anything, did you find with regard to deletion of data with respect to this search as it applied to the P list that you discussed before?
Recovering data that's been deleted from P list is not really possible. So all we can say is if this record exists within the P list, it hasn't been deleted.
Now, same question with regard to issues of deleted data with regard to the history DB.
There was no records of any, so there's no evidence of any records being deleted from history.db since early January. I think it was like the 3rd of January up to February 2nd.
And how are you able to tell that with regard to the history DB?
Again, every record is given a unique number, and there'd be a gap in that numbering system if a file or if a record had been deleted. The fact that there was no gaps indicates that nothing had been deleted.
And with regard to deletion, what, if anything, were you able to ascertain with regard to deletion versus web usage in the knowledge C database?
Knowledge C contains such a large amount of different type of data that's always being added and deleted for various reasons, none at the discretion of the user. It's a completely system-driven event to delete information from Knowledge C. So we can't say what was deleted from Knowledge C, but we can see that during the times of Safari usage, records exist within Knowledge C that indicate, or certainly appear to indicate, that nothing was deleted.
What, if anything, were you able to find with regard to deletion in respect to the browser state DB data?
Browser state did have numerous records that had been deleted. Some we were able to recover. 3 records from browser state all had a timestamp very similar to 22740. These were 3 records that had been deleted at some point.
What are some of the options for deleting data from that particular, from the browser state DB?
So the first most prominent option is to delete absolutely everything from the device, or delete all history from the device, which, as I mentioned earlier, we know that didn't happen because we still have other records. So the only other real option is to delete selectively. That could mean delete one at a time, and it could mean delete either the full day, the last 2 days, or last hour. But in all of those cases, the record must exist in history.db in order to be deleted from browser state. The fact that this record, the hostlong and the how long to die and the key don't exist within the history database would mean that the user would never have the option to selectively delete that record.
Yeah, go, Sean.
Yes.
Let me go back over that one more time.
Would never have to be deleted. Delete one of the records. Or the first
Options for deleting data from that particular, from the browser state DB.
So the first most prominent option is to delete absolutely everything from the device, or delete all history from the device, which, as I mentioned earlier, we know that didn't happen because we still have other records. So the only other real option is to delete selectively. That could mean delete one at a time, and it could mean delete either the full day, the last 2 days, or last hour. But in all of those cases, the record must exist in history.db in order to be deleted from browser state. The fact that this record, the hoslong and the how long to die in the Cont'd don't exist within the history database would mean that the user would never have the option to selectively delete that record.
Yeah, bro, Sharon?
Okay.
Yes.
So it sounds like what he's saying is if it's been deleted from either way, whether it's somebody has deleted all of their browsing history or deleted like just browsing history from a particular time span, like a day or a week or a couple hours, in order for that to have been deleted from the browser state, from the WAL file, that write-ahead log, the whiteboard version of it, then it would have had to have shown up in the history.db, the permanent database that's related to search terms. So if there's no evidence of it in the WAL file and there is evidence of it in the history.db, but I'm not sure if I completely follow that. Yeah. Okay. But basically what he's saying is there should be a record one way or another. Yeah. So, but yeah, very, very point well taken. Travis James, just think the jury can't pause this and rewatch. They can't. If I'm on the jury, this is going way over my head.
The browser state DB records.
Is that, sir?
I do. Yes,
Do you recognize that, sir?
I do, yes.
What do you recognize that, sir?
So this is a list of the browser state DB records showing a red line where a record or more have been deleted.
And again, the term deleted, as far as it applies to this particular area of the database, what exactly does that mean again?
It means the record has been marked as deleted. If you were to read this database in a regular database application, you would not see it, but it doesn't necessarily mean that we can't recover it.
May I approach again, Your Honor?
Yes.
I'm also seeking to introduce and the next exhibit.
The exhibit?
I have no objection to the exhibit, if that was the question.
That is the question.
Okay, we're good.
Thank you.
Your Honor, with court permission, may we publish exhibit 622 to the jury?
Yes.
Again, sir, what's up on the screen, is that what you have before you as exhibit 622?
It says yes.
And if you could, please, using the laser pointer, direct the jury's attention to what, if anything, of significance you observe in this.
So again, we can use the number down the left side, which will identify the unique identifier given to each of these records. And we can see that the red line between the first two records indicates that records between 3986 and 3993 have been deleted. We can see that record 4001 is deleted. Records between 4004 and 4019 have been deleted. Record 4020 was deleted. And then finally, records between 4025 and 4031 had been deleted also.
Now, sir, as far as records 4024 and 4025, what, if anything, were you able to ascertain as far as the dates and times associated with those?
Yeah, so these particular records show up at 227.31 and 227.33 respectively. And this matched records within Knowledge C that showed that at this particular time when the tab took focus, that particular website was also shown visible to the user in Safari.
Now, as far as the date and time for 4024 and 4025, what, if anything, did you observe with respect to the date and time for 4026? And what can you tell about that?
So 4026 was approximately a second or two after the record here, 227.33. I believe it was at 227.35. And then again, there was another record, 4027, which again was another 2 or 3 seconds after that time. So within a 9-second period between 227.31 and 227.40, there were 5 records within browser state DB that had a timestamp within that 9 seconds, all with completely different types of website, ranging from PayPal, banking, YouTube, and the hoslong Steiner code.
Sir, with respect to, are you familiar with the term called spontaneous deletion?
I believe so.
And can you explain to the jury what that is?
It's not a term I would use, but essentially a cleanup operation would occur on the device where it would look for orphaned records records that are old enough to not be required anymore, and they would just be deleted by the system without any direction from the user.
Now, during the testing that occurred, your testing, which occurred with respect to this device, what, if anything, did you observe with regard to spontaneous deletion?
I wasn't able to replicate the spontaneous deletion. I was able to replicate completely orphaned records. So a record that existed in browser state without a corresponding record in history.db. And it meant that there was no way for me to delete that record manually without deleting everything from the device regarding history.
May I approach, John?
Yes.
Okay. They need a sidebar.
Yes, sir.
As one.
Okay. What's going on?
All right. So you're introducing those 4 pages or whatever it is, Mr. Lally?
Yes, sir.
As one exhibit?
As the next 4 exhibits.
Okay. All right. So those will be admitted. Were you going to publish those? Because you can go ahead and publish them while this is.
I don't think that's.
Yeah. Great.
Showing the history database at 2139.34 on the 27th of January and 2255.09 on the 27th of January.
May I approach again, Your Honor?
Yes.
I'm off to introduce the next exhibit.
All right. So all 4 are in. Okay. So you don't need to. You already marked them?
They have not been marked.
Okay. Exhibit 623.
May I have one moment, Your Honor? And Your Honor, the court's permission if we could publish that to the jury.
Yes.
Now, sir, with regard to this, we're looking at record number 4026. Is that correct?
Yes, I believe we are.
And again, if you could direct the jury's attention to what exactly are we looking at in this exhibit with regard to record 4026?
Yeah, so in the right column, we see the source of the information. So history.db is the database. History_visits would be the table. And then the unique identifying number of 31407 and 31408. We see that the start time, or the time that particular website was navigated to, according to history.db, was, as I say, both on the 27th of January, one at 21:39 and 34 seconds local time, and one at 22:55:09 local time. And both of these websites are related to Hock and Mock Sports. We have the URL at the top, followed by the title of the page, followed by a visit count that tells us how many times that page has been visited before.
I'm confused. I don't understand why we're even looking at this, because the date says January 27th, 2022. Like, it's throwing me off. I don't understand why we're looking at this for that reason.
Sorry, one moment, Your Honor.
Yes.
That next document, you recognize that, sir?
I do, yes.
What do you recognize that to be?
This is the same kind of report. This is related to the YouTube record that was part of the browser state database, related to It's Raining Men on YouTube.
Is that the record number 4027? Is that correct?
It is, yes.
Your Honor, may I approach again?
Yes. Okay. Exhibit 624.
Your Honor, very briefly, may I publish that?
Yes.
And sir, what's up on the screen now, is that what you have before you as the next exhibit?
It is, yes.
And again, if you could, using the laser pointer, just direct the jury's attention to what, if anything, of significance you observe in this record of 4027. Yeah,
so again, we have 5 records related to the YouTube video, It's Raining Men, starting at record 31398, 31399, 31400, 31401, and 31402. These were all accessed on the afternoon of the 27th of January 2022.
May I approach again, Your Honor?
Yes.
Another document, do you recognize that?
I do.
What do you recognize that to be?
This is the same again, related to record 4029. Shows that a website was visited on the 28th of January 2021.
And you want to ask that this be marked?
Okay.
Excuse me, as the next exhibit.
Okay.
And Your Honor, with the court's permission, may I publish that brief?
Yes.
Sir, what's up on the screen, is that what you have before you as the next exhibit in regards to record 4029?
It is, yes.
And again, if you could explain to the jury what we're looking at.
Yeah, so this URL, cantonma.org, relates to the URL that was provided in record 4029 of the browser state database. It shows that this web page was accessed at 1 p.m. And 17 minutes and 0 seconds, and 1 p.m. 17 minutes and 8 seconds on the 28th of January 2022.
May I approach again, Your Honor?
Yes.
Another document, sir, do you recognize that?
I do.
What do you recognize that?
Again, the same kind of report. Again, this time for record 4030 from browser state, and it shows access to Ozone Basketball.
And with regard to that report, as far as the same kind of report, that's from your tool, the ArtX tool, is that correct?
Correct.
And that ArtX tool, is that a widely available tool used within the field of forensic investigators?
Yeah, it's something that I say I've worked on for around 5 years. I've given it away free to the digital forensics community for 5 years. There's approximately 600 users globally, and it's taught as part of the SANS digital forensics training courses.
May I approach again just to retrieve, Your Honor?
Yes.
Yes.
Thank you.
May we publish that for the
Yes.
Your Honor? With regard to this exhibit up on the screen, record 4030, again, if you could just draw the jury's attention, or direct the jury's attention to what, if anything, of significance you observe in this exhibit.
Yeah, so again, we have records from the history database related to Ozone Basketball, and it shows that this website was accessed at 11 a.m. and 26 minutes on the 25th of January 2022.
May I approach, Your Honor?
Yes.
It's going to be. Now, with respect to sort of the totality of your analysis, Mr. Whiffin, what, if any, conclusions did you come to as to the timing of the 2 searches in question with relation to what you observed in your analysis and testing of this device?
Yes. So in conclusion, I determined that the tab that was used was focused at 227.40. So the tab was opened at that time, at which point it was being used to show Ozone Basketball and Hockomock Sports websites. The 6:23 timestamp is when the search was first conducted. Never loaded the page, otherwise there'd be a record in the history database. And while that page was still loading, a secondary search was conducted for Hoslong to Die in the Cold. Again, that page never loaded either, although these both did show up in the Knowledge C database to show that the browser was trying to display these pages. Safari was closed prior to the Hoslong to Die in the Cold record being shown on screen at all. But when it was reopened at 10:33, in regards to whatever other Safari activity was to be conducted, it appeared on screen. So we have a 10:33 record where Hoslong to Die in the Cold was shown on screen, even though the page never successfully loaded.
That's interesting. Okay, so what he said is that she made the search a couple times. She didn't wait long enough for the search to actually load either time. And then she basically minimized Safari or closed down her phone or something. Like did something so that it couldn't fully load. Turned away from it. And then at 10:33, she opened up Safari again. It loaded. And that's why there's a 10:33 a.m. entry that also says Hoslong to Die in the Cold. So, okay.
With respect to your analysis and your testing here, what, if any, opinion do you have as to whether or not any of the data marked as deleted was actually user deleted, or the user actually actively went through the process of deleting it.
Yeah. So again, we know that she didn't, or we know that nobody deleted the entire history. So that leaves the only option to be selectively deleting records. The fact that there are no missing records in HistoryDB shows that it's impossible that that record could have been deleted by the user. It would have just been orphaned in the database, and I believe would have deleted itself at some stage whenever a particular cleanup function ran. Although, as I said earlier, I haven't been able to replicate that. I was able to continue to read the various versions of the page that contained Hoslong to Die in the Cold browser state record, and found that it existed at the same time as another record that was created at least 2 days later. Therefore, I can determine that that particular record was not deleted until at the earliest, 10 p.m. on the 31st of January. And it's not possible that the user could have created or caused that deletion to occur.
Now, over the course of your analysis and testing or review of the extraction in this case, did you have occasion to review an affidavit of a Mr. Richard Green?
I did, yes.
And what, if any, opinions or conclusions do you have as to that affidavit?
I had issues with several of the statements being made as part of the affidavit.
And what issues were those?
Namely, it specified that Sellbright report identified that the search was conducted at 2:27:40. And as I've explained, I believe the tab took focus at 2:27:40, not when the search occurred. The report mentioned that Sellbright report identified it was deleted by the user. We don't do that. We'll tell you that a record is deleted, but we don't specify how the record was deleted. That's something for the examiner to determine. I forget. Oh, and then there was a mention of the purpose of the browser state database. The explanation given was correct for iOS 14 and below, but not for 15 and above, which is relevant in this case.
Now, you mentioned this issue as far as coming up, obviously, in this case and some other instances, phone calls or inquiries that you received from Austria and other places. What, if anything, have you or your company, Sellbright, done with regard to rectifying this issue?
Well,
I'll allow it.
okay, we recognize that this timestamp could be misleading. Regardless of how we label that timestamp, the very fact that a timestamp is there, we feel would be or potentially misrepresented. So the decision was taken to remove the timestamp altogether from that information. So now we show the web page was visited, but we don't attribute a time to that purely because it could be wildly inaccurate.
Your Honor, this may be the appropriate time for the instruction.
Okay. All right. So jurors, we're about to see a demonstration by Mr. Whiffin. It's simply a demonstration to help you to understand the evidence that you've heard. It's not evidence from this case, but it helps you understand the evidence in this case. You must decide this case based solely on a fair consideration of the evidence and nothing but the evidence. But this is a demonstration to help you understand that evidence.
Okay, I'm hoping that this really helps to clarify some of the stuff that he talked about. In the meantime, let me actually get some questions here because some of them might be more time sensitive to the testimony. This is probably a good place to pause it real quick and get those. Doctor Who 8675309. What, if any way, does someone take over the Chief Dingus crown? I don't know. It's going to take a bit to take that away from Andy. Spunky Nuggets, what, if any, poll will you put up regarding the conspiracy? I am going to remember. I'm not going to take this one out of my saved questions because I know that's something that we want to do. How many votes do we have in this poll? Okay, only not too many votes. So we're going to keep that one going for a little bit, and then I'm going to change it to the conspiracy poll because that's going to be curious. Sue B question. He said he didn't look at Wi-Fi, so why did Lally provide him with it? To be honest, I'm not completely sure on that part. Jonathan Willett question. So JM states she searched her daughter's sports site, turned her phone off, went to bed, and then woke up when John's niece called, but the Wi-Fi was connected until she left the house at 5:39. Lies. So yeah, I don't know if the connection to Wi-Fi means like through Safari, meaning that she was actively on Safari, or if that means that the overall device was connected to Wi-Fi. I'm not entirely sure. Dreaxo question. So Jen McCabe opened the tab at 2:27, did no searches, closed down Safari, reopened Safari and used the tab at 6, switched apps, reopened Safari app and did the other search in seconds. So open the tab at 2:27. Yes. No searches. I think that what he's saying here is that she did do some searches at that hour as well, or at that time. And that was the Ozone basketball and the Hockomock sports, that she looked those up in the tab at 2:27 a.m. then she didn't close down the app entirely, but she put Safari in the background, I think. Reopened Safari and then used a tab at 6, switched apps, reopened Safari, and did the other search in seconds. So around 6:30 a.m. She then searched for these other the Hoslong to die in the cold. 6:23, 6:24 is what they're saying. Joshua Marshall question, but he said it was attempted to be searched, but the search failed, didn't he? Yes, he said that at 6:23, 6:24, basically she didn't allow it to load before she like turned away from the Safari app. I don't think it was closed entirely, but I think it was maybe minimized, or she pulled up another app or something like that. That's my understanding anyway. I could be wrong on that. That's my understanding. Sue B question, can Lally get sanctioned for putting the jury to sleep? No. But to Draco Amy's point here, is this really in evidence if the jury doesn't understand it? If a tree falls in the woods and no one is there to hear it, did it really make a sound? If jury is admitted in front of, or admitted and explained in front of the jury and they are asleep, is it really in evidence? That's a big issue for the prosecution on this, even though to me, from what I have been able to understand, it all sounds like it's making sense. Not everything that that they've talked about with this witness have I picked up, because it's incredibly technical. But jury could be asleep right now, in which case they're not hearing any of it. Spunky Nuggets, is the jury allowed to not consider evidence if they don't understand the science and technology? Yep, absolutely. Sue B, thank you so much for the 1.5x and for explaining. My head is going to explode and can't retain any of this. No problem. Jerry Roth, Legalbytes, why are we getting rebuttal witnesses before the witnesses they are rebutting? Well, because they anticipate that there's going to be some testimony coming in from the defense, and they also can put on witnesses before they do that, because this is the prosecution's case in chief. Kristen O, Legalbytes, why did they have that woman last week speak on this too? Why does prosecution keep hitting on this one search when so much else is bad in the actual investigation? It could be because this actually is their best point, because everything else they have is garbage. That could be one reason. Could be a number of other reasons as well. All right, let's get to this demonstrative that they're going to be putting up on the screen. I'm hoping that this will help to clarify what this witness is talking about, because like I said, there are some parts of it here that I'm feeling a little lost on.
Correct.
Yes.
Thank you. And so to that point, Mr. Whiffin, were you able to prepare a demonstration in regard to what you've been discussing through the course of your testimony?
I was, yes.
And that demonstration doesn't specifically reflect on the searches or the extraction report that you looked at in this case, correct?
Correct.
But as far as the overall issues that you've been discussing in your testimony, correct?
That's correct.
And with court's permission, may the witness now illustrate that.
Yes.
Okay. So first of all, on the left there, you can see a screen of an iPhone, and that is a phone I have in front of me live. It's just demonstrating what I can see on the phone. This is my Artex tool, and the feature which I continuously use this tool for, which is not available really in any other vendor tools, is the ability to create a live connection between my computer and the phone. The live connection is what I've just started here, and what's going to happen is all of the files and folders that exist on the phone will be mapped to my computer so that I can navigate it. I can look around and I can take a look at near enough live records on the device. Prior to the availability of this tool, I would have to test a theory on a phone, do an extraction, and then pass the extraction, which could take anywhere between 20 minutes and several hours. The reason that I'm using this tool today is because I can do those same tests within 10 or 20 seconds, typically. So I just need to wait for this section to do. So it's already mapped out all the files and folders. It's now asking for a few important pieces of information, which it will then populate on the screen. So information such as the device, serial number, etc. What we're interested in, though, is the browser state record. So I can go to the browser state database and take a look at that and open that up. And you can see that at this moment in time, I have no records in the database at all. If I go back into the live view of the phone, you can see I have Safari open from last night. So it's been sat in the background overnight and not doing anything. But at 10 past 8 last night, I performed this search in a brand new window. So started Safari, opened up a new tab, immediately searched for new tab at 2010 on the 16th of June. If I now search for the time right now, 1442, what I can do is go back to my Artex tool and press this reload button. That's going to delete the database from my computer only and copy the most recent copy of the database and WAL file from my phone back to my computer, where it shows me I still have no records. That's expected behavior because at the moment I've not closed the tab. So if this, again, was iOS 14, there would be a record there to say what tab I had open. But iOS 15 doesn't work that way. If I now go back to my tabs and actually just close this.
I will say this bit that he's referred to the difference between iOS 14 and iOS 15, that there's been some changes about how browser state DB does things. I wish that we could just know definitively. Jen McCabe had iOS 14 or iOS 15 at the time of this incident, or at the time that this stuff was all happening, so that we could just not pay attention to like this little complexity versus that little complexity. I don't have the capacity to hold both of those in my brain. I don't know if anyone on the jury does. So I wish that he would just like definitively say, this is what was on this phone. And so like we can just say, just move forward with that. It's a little too much detail, which is already a bit overwhelming here.
Window. I can go back into Artex and hit reload again. And we now see we have some records. I can look at this particular record and you'll see the title is 1442 Google search. You'll see the Google search record here. So I just need to change the time zone as well to Eastern time. So you see it's the most recent search which I conducted, the 1442 search. The last viewed time, though, still shows as 8:10 p.m. last night, because that's the time that the tab was focused, not the time that the search was conducted.
Thanks. Let me have a moment, John.
Yes.
Thank you, sir. I have no further questions.
Okay, Ms. Giannetti?
Thank you, Ron.
Okay, cross-examination.
Neither computer was used. One.
Come on, why does it do this to me? Okay. Okay, there we go. I hate it when it makes me go live when I don't want to go live.
Good afternoon, Mr. Whiffin.
Good afternoon.
Sir, you had spoken a little bit about what was your assignment here in terms of the data that was sent to you. And I believe that you testified regarding that 2:27 a.m. or 2:27 and 42nd a.m. timestamp that it didn't make sense to the investigators, correct?
Correct.
Were you told that one of the investigators was Trooper Michael Proctor?
I don't recall any names being mentioned. The ticket came to me, or the request came to me via another Cellbrite employee who'd been asked about this case and asked whether we could offer any help.
Okay, thank you.
Guaranteed Trooper Michael Proctor was confused about this because there's no way that he has the capacity to understand based on the way that he testified. So I know that that's just insulting his intelligence level, but I'm guaranteed there's no way that he was sitting there and trying to analyze this and understand it and was like, oh, you know what? Let's get another expert.
You would agree with me that when you're...
By the way, I slowed it down to normal speed now because Yannetti, like Jackson, talks a lot faster than Lally.
making or doing a simulation, you want it to be as close to an apples-to-apples comparison as you can get.
As best possible, yes.
And to get truly accurate research results, you want to eliminate as many variables as you can, correct?
Correct.
You wouldn't, for instance, want to use an Android operating system to try to replicate the activity from Jennifer McCabe's Apple iPhone, correct?
Correct.
What version of iOS did you use for your testing of Jennifer McCabe's data?
So this test has been undertaken on various different versions of iOS. from iOS 12, 13, 14, 15, 16, 17, and most recently on the beta version of 18 last week. This particular demonstration was on 15.8.2.
Okay. And you're aware, you said 15.8.2.
Correct. I've also tested on 15.7.
Oh, fair enough. You're aware, however, that Ms. McCabe was using iOS version 15.2.1, correct?
Correct.
And you would agree that the way that an artifact is stored would depend on the iOS version that you use, correct?
Correct.
And your simulation did not use the iOS version that Ms. McCabe was running on her iPhone, correct?
Correct. I used the closest version I could find.
So I'd like to ask you some questions about the characteristics of browserstate.db-wall in record number 4028. If I can.
Okay.
That record number, I believe you testified, was found to be deleted, correct?
Correct.
But you were able to recover the date and time associated with it, correct?
The date and time of the last viewed?
Of that record number.
Yes.
And what was that date and time?
2:27 and 40 seconds a.m.
You were also able to recover the content of that particular Google search itself?
I was able to recover the URL for it, yes.
Okay, and what was that Google search?
Hoslong to die in the cold.
And it's true, however, that the session history could not be recovered, correct?
That's correct.
Now, given those characteristics that you've just discussed, did your testing result in a WAL file record, a WAL file record, that matched the characteristics of 4028? In other words, deleted with session history not recoverable?
The issue with the session history, I was able to recover only the first page of session history. What happens is when there's a large amount of data that's split over multiple pages, if it's a live record, all those pages point to each other so that you can chain it together and get one large amount of information. Once they've been deleted, some of those pages can be overwritten and therefore the pointers don't make sense anymore. So the amount of information in this session was way larger than one page, and I wasn't able to recover anything further.
Okay, and you'd agree that the simulation was done using a different operating system, correct?
Correct.
Were you able to recreate the other deletions that appeared before and after that record 4028?
Which deletion, sorry?
Well, you had testified, and I believe there was an exhibit that was introduced that showed that there were multiple deletions both before and after, correct?
Correct.
Were you able to recreate those deletions?
When I manually deleted records from the history, then the records also were deleted from the browser state.
Now, I believe that you testified, and if you didn't, I believe it's in your report, that there are essentially 5 mechanisms for record deletions in the browser state database, correct?
Correct.
You ruled out 4 of them pretty quickly, correct?
Correct.
And I believe you've testified to that today, correct?
Correct.
The only remaining option was selective deletion by a user, or there's some internal mechanism for record deletion that is not fully understood, correct?
Correct.
All right. And you know of, as you testified today, you know of no internal mechanism for record deletion that's not fully understood, correct?
I've not been able to replicate that function, no.
All right. If there is no unknown internal mechanism for record deletion that's not fully understood, that would leave selective deletion by a user, correct?
Not in this case, no.
All right. Well, selective deletion, you would agree, means that a user selects what to delete, correct?
Correct.
And regarding the user, the term user, what is that? Who is that?
Whoever's using the phone at the time.
Okay, so it's actually somebody who is using the actual iPhone itself, correct?
Correct.
Not necessarily a computer expert, correct?
Correct.
Would you agree with me that somebody who had access to the data before it was extracted and sent to you could have made selective deletions of the data?
Objection.
I'll allow
No, I don't.
Are you aware of an app called MySQL?
Yes.
What is MySQL?
MySQL is just a method for viewing SQLite databases.
All right. If someone had access to the raw data, again, before it was sent to you, and used that app, they could make selective deletions of the data, couldn't they?
I assume you're talking about opening up the extraction, taking out the particular file and editing it?
I'm sorry, I interrupted you. You're right, Your Honor. I apologize. And I apologize to you. If you could restate your question or answer or give me your full answer.
Okay. So it would be possible with the extraction to take out particular databases, alter them, and put them back into the extraction. But there's something called a hash mechanism that we have in place that would it essentially hashes the original data, and then it can be hashed again at a later date. It results in a long string of characters, and if there's any changes to the original data, then we'd see that it's been modified.
Would you agree with me that someone with access to that data and an appropriate application or program could also delete and renumber history.db and knowledge.cso so that it would appear as though there was no break in the numbering, so that it would also appear that nothing was deleted?
It's potentially possible, but would require a large amount of knowledge and skill to do in a way that can't be detected.
Thank you very much, sir.
I think
that.
that,
Riley?
I think that what Yannetti was getting at is it sounds like someone would have had access to not necessarily just the phone like Jen McCabe, but someone who had access to the extraction, then goes into the extraction report, changes things around, moves it back in, and then I guess manipulates even the hash mark, I think. So it couldn't have been Trooper Proctor, because I don't think he has the expertise or any of that. But, he did say on the stand that he was like, any modifications are going to have a new hash mark. So I don't know how someone gets around that unless they truly are like very, very well versed in this kind of stuff. Certainly above my pay grade, that's for sure. Okay, we're going to go to redirect now.
Any discrepancy between the iOS version in Ms. McCabe's phone and the iOS version in the demonstration that you did? What, if any, impact does that have on what you showed this jury?
So in this particular case, every iOS version that I tested, as I mentioned, from 12, 13, 14, 15, 16, 17, and 18, the timestamp is always referring to the time that the tab took focus. So even though there are some differences with when the record's created, the meaning behind that timestamp has been consistent.
Now, what you were asking about what you were asked about in regard to selective deletion, you indicated that there's no evidence of that in this case. Is that correct?
Correct. Selective deletion would require that the record existed in the history database in order to be selected to be deleted. The fact that there's no missing records indicates it was never written into that database and therefore could not have been selectively deleted.
Now,
Okay, I'm going to change this to 1.25.
the hash mechanism that you testified as far as detecting whether or not someone had surreptitiously gone in and deleted things. Did you see any evidence of that in your review of the extraction of Mr. Cave's phone?
I didn't have access to the hash information to see whether any changes had been made. That's something that the original examiner would have had access to. From my point of view, there was nothing in there that would indicate that tampering had occurred. The timestamps all made sense for the files. The historical pages all made sense. So it's probably possible, but it would take a large amount of skill to do.
Now, with regard to your analysis and your testing in this case, again, what is your opinion or conclusion as to when these two Google searches were conducted?
I'm of no doubt that the only time those two searches were conducted was at 6:23 and 6:24 on the morning of the 29th.
Thank you, sir. Nothing further on.
Okay.
Prior to today, have you ever heard of spontaneous deletion?
Hang on 1 second. Gunnar Dennis, thank you so much for the super chat. Proctor's FBI IT friend. I think you mean Higgins' FBI IT friend. But that person only touched Higgins' extraction, not Jennifer McCabe's. Jennifer McCabe's extraction was handled or she handed in her phones to Buchanan and to Proctor. So the FBI friend didn't touch Jen's phone. Okay, let's go back really quick. Okay, because I want to make sure that I'm getting this recross. I'm getting a little bit bogged in the weeds. I'm not gonna lie. Okay, recross. Here we go. All right.
On the morning of the 29th.
Thank you, sir. Nothing further on.
Prior to today, have you ever heard of spontaneous deletion?
It's not a term that I'm familiar with.
Thank you.
All right, sir, you are all set. Thank you very
Thank
much.
you.
Okay.
Do you need a couple minutes to take your stuff down?
I can probably be quite fast. Thank you.
Oh, goodness.
All right, Mr. Lally, your next witness, please.
Yes, Your Honor. The Commonwealth called Trooper Nicholas Guarino to the stand.
All right, Trooper Nicholas Guarino, another member of the esteemed Massachusetts State Police.
I should give the court and jury the case down here. The truth, the whole truth, and nothing but the truth. So help you God.
Yes, sir.
Thank you.
Good morning, Your Honor. Oh, good afternoon now. Good afternoon.
Good afternoon, sir.
Good afternoon, sir.
Could you please state your name and spell your last name for the jury?
Yep, Nicholas Guarino, Guarino.
And how are you employed, sir?
I work for the Massachusetts State Police.
And how long have you been a member of the Massachusetts State Police?
This is my 9th year now.
Now, prior to working with the state police, what, if any, prior experience did you have in the field of law enforcement?
I was a local police officer in Norwood for almost 11 years.
Now, with respect to your role within the state police, where is it that you work now?
I currently work at the Norfolk District Attorney's Office.
And within the detective unit, is that correct?
Yes, that's correct.
And with respect to that, what, if any, specialized role do you have within the detective unit attached to the Norfolk DA's?
Yeah, I conduct cell phone forensics, computer forensics, and I also do sexual assault investigations.
Now, with regard to the electronic forensics, what, if any, specialized training have you received in that particular area?
I have about 300 or so hours at Cellbrite, CCO, CCPA, cell phone repair forensics, Berlin motor vehicle forensics, Axiom magnet cell phone and computer forensics, X-Ways. These are all different programs used for cell phone and computer forensics.
Now, sir, at some point, did you become involved in the investigation involving the defendant Karen?
Yes.
And with respect to that, let me just ask at some point, did you become aware of an affidavit from a defense expert named Richard Green?
Yes, I have.
And sometime following that, did you have occasion to reach out to Cellbrite with regard to what had been posited by Mr. Green in regard to two Google searches contained within Jennifer McCabe's phone?
Yes, I did.
And eventually, at some point, did you have occasion to speak with the gentleman who came in here right before you, Mr. Whiffin?
Yes, I did.
And so that wasn't Trooper Proctor that had reached out to Mr. Whiffin or had any communication that you're aware of with Mr. Whiffin, correct?
No, I reached out after the defense expert's findings were released, and I read his report.
And did you also have occasion to review a report from Ms. Jessica Hyde?
Yes, I did.
And with respect to those two reports, what, if any, conclusions or opinions did you come to independently in relation to those opinions of Ms. Hyde, Mr. Whiffin?
Objection.
Sustained.
Now, Trooper Guarino, you had mentioned that you've had specialized training in regard to something called BURLA, correct?
Yes.
Could you please explain to the jury what BURLA is and how is it used in criminal investigations in your line?
So Burla is a specialized hardware and software used to download the infotainment and telematics modules in a vehicle. So telematics module is basically like the SIM card for the car, and the infotainment system is your radio head unit that enables you to have Apple Play, CarPlay, or Android or Google Play for the vehicle.
Okay, so he's going to testify about the infotainment system. That's good. I hope that we can get some important information about that.
And at some point, you made aware of a search warrant that was authored in regard to seizing the infotainment system from Ms. Reed's vehicle.
Yes, sir.
And just so the record is clear, can you describe Ms. Reed's vehicle as far as what type of vehicle we're talking about?
Yes, it's a Lexus LX 570 SUV.
And specifically on February 2nd, 2022, did you have occasion to remove that infotainment system from the vehicle pursuant to that search warrant?
Yes, I did.
And once that item was removed from the defendant's vehicle, what, if anything, did you do with it?
After we removed it from the vehicle, it was brought back to Norfolk DA's office for a data extraction or attempt to.
Oh.
And that data extraction, if you
Oh, okay. So there's going to be, I don't think we're actually going to get any information from it because he just said, or at least attempt to. So something tells me they're not going to have gotten any information from it.
know, based on your training experience, sort of how is that conducted, or what is the process of extracting data using BURLA?
So depending on the system, it's dismantled. They have the specialized hardware that actually goes onto the motherboards of these systems, and we're able to pull the data. Or the other option, if that's not viable, is to do a chip off where we have to basically destroy the motherboard and take the memory chips off the devices to try to get the data that way.
Now, with reference to this specific device, what, if any, efforts did you undergo in order to extract the information without using the chip off?
So at the time that we pulled the system, it was not supported. I emailed Burla and called them, see if they had a timeline of when this might be supported so we could get the data. We deemed chip off last support, as a last resort, because it is a destructive process. So once those memory chips are taken off, the likelihood of trying to reattach them and get it to work again is very slim.
Let me stop you there for a second. When you talk about an item being supported, what does that mean?
Whether or not Burla has the ability to pull the data from that vehicle.
And how is that sort of determined, or how are you able to ascertain whether or not a particular vehicle, make, model, manufacturer is supported by the BURLA device?
They have an app, and they also have the tech support. But if you put in the VIN of the vehicle, or if you don't have the VIN, you have the make, model, and trim level, like limited or XLE or whatever, you would be able to go in and look it up and basically say, Burla will tell you, yes, it's supported for GPS points, or it's supported for diagnostic data, or whatever that they're able to get out of the vehicle. And they work with the automakers to get these get this data. So
I have a question. If this is something that is a destructive sort of process, meaning that what he just said, that you can't then put the infotainment system back into the car and then reconnect it and try to get the information, isn't that something that they could have verified before taking out the infotainment system to see if they could in fact pull data from it using Burla, right? Like, I feel like that's something that they could have double checked before doing that. This is okay.
And approximately how many different types of if we're looking at sort of the entirety of different makes and models of manufacturers, if you know, sort of what percentage of those types of vehicles are actually supported and Burla can actually extract information?
I don't know as of right now. It's a lot, and they're constantly updating it, so they are able to do more vehicles as time goes on.
Now, at this particular time, as you sit here today, June 17th, 2024, the vehicle that the defendant was operating on January 29th, 2022, is that vehicle available or supported by Burla at this time?
The trim level that the defendant had is not still supported. There is Toyota and Lexus support now, but it's not, unfortunately, for her model. Now,
you mentioned that you had reached out to the Burla company for updates as far as the availability, or when the defendant's vehicle might be supported. Is that correct?
That's correct.
And about how many times and over what time period are we talking about that you reached out to ascertain?
Immediately, when I did the extraction, I should say extraction, but when I took the system out of the vehicle, I had to reach out to Burla because where it wasn't supported, they actually had to send me tech diagrams so I could go in and, again, not destroy the whole vehicle as I just took those components out. Over the next, almost 2 years, year and a half of going back and forth with them, with their support and their sales team.
And when you say going back and forth, how often were you reaching out to them, or how often were you getting a response in regards to it?
Usually every few months, I want to say every 3 months, give or take. I forget the exact number, but phone calls or an email to them asking.
Now, beyond that, are you familiar with a national cyber crime conference?
Yes.
And do you attend that on an annual basis at least?
Yes, I do.
And with respect to that, what, if any, time at those conferences did you spend dedicated to ascertaining the availability or supportability of this vehicle with reference to Burla?
So Burla has a booth at the National Cybercrime Conference. I spoke with their sales team there. Their response was to keep calling Burla, keep pestering them, and they might actually get the support sooner than later.
And again, were you ever able to ascertain or get the support to download the information from them?
No, unfortunately.
Now, at some point, were you able to download any information from that particular infotainment system from the defendant's vehicle?
And not from the infotainment system, but Burla released a new item similar to a mechanic scan tool. It plugs into the OBD2 port, which is underneath the dash. So if basically if a mechanic went in there with a scan tool to tell you why you have a check engine light, this does something similar. So you plug it in, and then it pulls the car diagnostic data from that.
And as far as the data that you received from that, what, if anything, did you observe?
Again, I got a series of 14s was the numbers. It was no readable data. I reached out to Burla and asked them, I said, is there a reason why I pulled this data, but when I put it into the software, it's not telling me anything. It's not giving me any readable data. And they said they know it is diagnostic data, but they haven't got anything from Lexus to say these 14s, these codes mean this. Oh, they only know it as emissions.
So was Burla itself able to read that information and transform that sort of binary code into any sort of readable data for it?
Other than the number 14, no.
Now, from there, what, if anything, did you do with regard to the Burla and the defendant's vehicle?
Was placed back into our digital evidence lab, and then we did eventually do a chip off to the device.
Now, with respect, to the chip off, that was done sometime in December of 2023. Is that correct?
Yes, that's correct.
And again, if you could expound upon a little as far as, can you describe for the jury sort of the chip off process, why you were reluctant to do it, and what's entailed in it?
As I said before, it is a destructive process. As soon as we do it, we take those memory chips off. It's applying extreme amounts of heat to the motherboards to take the memory off. That'll heat it. You lose a lot of the soldering and capacitors, anything that's on that motherboard. So, like I said, once the memory chips are taken off, it's going to destroy the board.
And as far as that chip off process, who, if anyone, was present with you, or who, if anyone, assisted you in removing that or conducting that chip off process with regard to the motherboard from the entertainment system from the defendant's vehicle?
I'm sorry, at the time that we actually did the chip off?
Yes.
Yeah. It was myself, AG Speak, and Maggie Gaffney.
And who is AG Speak?
AG Speak has his own forensic company, I guess you could call it, for Burla. I could consider an expert in the field, former California Highway Patrol officer that exclusively handled stolen cars.
And who is Ms. Gaffney?
She was a defenses expert. She's the one who actually did the chip off, applying the heat and taking the chips off in our presence. And she, I believe, works for, I'm sorry, the name of the company escapes me at the moment.
Now, with respect to the information that you, Ms. Gaffney, and Mr. Speak were able to remove pursuant to that chip-off process, what, if any, usable information were you able to glean from that?
As I was told by AG, there was no data that was recovered off the infotainment system or the telematics module from the chip-off.
And as far as Ms. Gaffney, did you have any conversation with her as far as the information that she was able to glean or read or decipher?
No, once she did the chip-off, I had not spoken with her since.
You have a moment, John?
Yes.
Now, Guarino, at some point in late January, early February 2020, were you provided with some a laptop and/or desktop computers from the home of Mr. O'Keefe?
Yes, I was.
And what, if anything, did you do with those?
One was a Dell laptop, the other was a HP all-in-one desktop. I removed the hard drives from both systems and used.
Objection, may be seen, Your Honor.
Okay.
All right. Fast forwarding.
All right, Mr. Lally, you can continue.
So Trooper Guarino, there was a Dell laptop and an HP Pavilion all-in-one desktop, correct?
Yes.
These were taken from Mr. O'Keefe's home, is that correct?
Yes, they were.
What, if anything, did you do with respect to those computers?
As I said, I took the hard drives out of both machines. They were imaged, and the images were loaded into Axiom to view the data that was on them.
Now, when you say something was imaged, can you explain to the jury what you mean by that?
It's a bit-for-bit copy of the hard drive. Instead of us turning it on and going through it, which would change data, by taking the hard drives out and imaging them, it creates a one-for-one copy, so that way we can view it without changing anything in the system.
And you mentioned a tool called Axiom, is that correct?
Yes.
And can you explain to the jury sort of what is that Axiom tool and how does it work?
Yeah, it's another forensic tool that we use. Can do cell phones, computers. You'll use it to load the images so we can view the data.
And with respect to the imaging that was done with regard to the Dell laptop and the desktop, what, if anything, was it that you were looking for specifically on those devices?
We were looking for a Ring video to see if either computer was used by Officer O'Keefe as a login machine to handle the account.
And from your review of what was extracted or imaged from each of those two respective computers, what, if any, information were you able to glean in reference to Ring.com or anything else?
Neither computer was used. One appeared to be used mostly by the kids, and the other, I believe, was a laptop, was used mostly by O'Keefe, but there were no Ring logins.
As far as the Ring connection, what, if any, devices were you, throughout the course of the investigation, were you able to ascertain were actually connected to the Ring cameras at Mr. O'Keefe's house?
Officer O'Keefe's cell phone.
Now, if there were any other devices, whether they were Mr. O'Keefe's or someone else's, ascertained from either the Ring footage or the information provided by Ring, whether or not there were any other devices beyond Mr. O'Keefe's cell phone that were linked to that account?
Not that I know of.
And I'm sorry, just not that there weren't any devices or not that you could tell?
Not that I could tell or that I ever heard of.
Now, Trooper Guarino, let me ask you some questions just in general about a cell phone extraction. You familiar with that term?
Yes.
And can you explain to the jury sort of what is involved in that and how a cell phone extraction is performed as far as your experience with regard to investigations that you've been involved in?
Yeah.
We don't need to hear this again. We've literally had like days of testimony about cell phone extractions. The jury knows what a cell phone extraction is by now.
So most investigations, we get the cell phones from the scene, from a suspect, from a victim. They're put into airplane mode to preserve the data. So that way a remote wipe can't be sent to the phone from iTunes. If we can't put it into airplane mode, we'll put it into a Faraday bag, which blocks the cell phone signal. And then it's brought back to the lab and put into a Faraday box, which has electrical outlets inside of it. So that way we can keep the phone charged.
And with regard to this investigation, you involved in the extraction of data or the examination of extracted data from any particular phone?
Yes, I did John O'Keefe's phone, Karen Reed's phone, and we had two witnesses' phones, but I don't remember doing the extractions themselves.
But as far as the data from those phones, have you had opportunity to look at that data? Specifically, I'm asking about both Jennifer McCabe's phone and Ms. Carrie Roberts.
Yes, I have.
Now, were you also at some point provided with some material from Brian Higgins' phone?
Yes, I saw screenshots of text messages.
And from the material that you were provided with reference to Mr. Higgins' phone, were you then able to cross-reference that eventually at some point with respect to the information in both Ms. Reed's phone and Mr. O'Keefe's phone?
Yes, I was.
From what you reviewed, was the information contained within the material provided by Mr. Higgins, was that consistent with what you observed in Ms. Reed's phone as well as Mr. O'Keefe's?
Yes, I didn't see any differences in those messages.
Now, with respect to, starting with Ms. Reed's phone, that was received by you on January 29th, 2022, is that correct?
That's correct.
And do you recall about what time it was and where you were when you received that phone?
I want to say 6 or 7 o'clock at night at the Norfolk DA's office.
And who did you receive that phone from?
Trooper Proctor.
And with reference to that phone, what condition was it in at the time as far as you referenced airplane mode, Faraday bag, things of that nature? How was it sort of when you received it?
I believe it was in airplane mode. The phone was in good working order. The and it was placed downstairs in our lab plugged in to keep the phone battery charged.
Now, the same with respect to Mr. O'Keefe's phone. When and from whom did you receive that, and what kind of condition was that in when you received it?
I also got that from Trooper Proctor the same time as Ms. Reed's phone. Same condition.
Now, with respect to the defendant's phone, at the time that you received it, did you have any passcode or any way to get into the phone?
I'm sorry, whose phone?
Ms. Reed's phone.
Oh, no. The software we use to try to bypass passwords to be able to extract the evidence, I should say the extraction of the data to look for evidence, with her phone at that time was not supported.
Now, what, if anything, did you do with her phone in regard to that?
Again, made sure it was in airplane mode and just kept it plugged in until such time as the phone was supported, and then we could download it.
Familiar with a device called the Gray Key?
Yes.
And can you explain to the jury what that is and what, if anything, you did with regard to the defendant's phone and the Gray Key device?
Yep. So Gray Key is, again, specialized hardware and software used to plug in the phones, can do Apple or Android phones to bypass passwords.
And how does that sort of function, or how does that work as far as when you hook something, a cell phone or a cellular device up to a Gray Key tool? What is it doing and how does it work?
If I knew that, I'd be a millionaire. But it basically installs software onto it, and instead of when you put in 10 passcodes to an iPhone, on the 10th one, if it's wrong, it kills the phone forever. This has some secret software that's able to bypass that and basically keep it in the phone with passcodes until it finds the right one.
So it essentially runs a bunch of different combinations of passcodes into the phone until it comes up with one that actually opens it.
Yes, that's correct.
And at some point, did the Gray Key device actually break into the defense?
Yes, it did.
Do you know about when that was in relation to when you received it?
Yeah, so we got the phone in January. It took, I believe support came out in, I want to say May or June. I don't remember the exact month, but we didn't actually get the passcode until August 16th of 2022.
And once that passcode was essentially broken into by the Gray Key device, then you're able to look into the phone. Is that correct?
Yes. Once the passcode's obtained, we download the data, and then we're able to take that extraction data and then open it up in Cellbrite or Axiom or whatever tool we're going to use to view it.
And the tools, as far as you're referring to, Cellbrite and Axiom, are you familiar with those tools through your course of your investigator with regard to electronic devices?
Yes.
And if you could explain to the jury sort of when you say Cellbrite and Axiom, as far as them tools are concerned, how do they work and sort of what is it that you do with the device with reference to Cellbrite?
So what do we do with the extractions once we go to open them?
Well, how is the information extracted, first of all, and then what, if anything, do you do with that?
So Gray Key will pull the extraction. Well, it just, once the code's received, it again uses its software, pulls the data out, puts it into an encrypted, it's MD5 or SHA. It's an encryption key that has, it's a unique key that, so if you change anything inside that zip file, it would change the encryption number to show that something was tampered with. We take that encrypted zip file and we open it up in the software, and that's able to say, you know, the call logs, the chats, the photos, the whole timeline of the phone.
Now, in addition to yourself, is there anyone else that works in this sort of capacity within your unit at the district attorney's office?
Yes, 2 other people.
And who are those 2 other people?
The director of our lab, Samantha Vogt, and Trooper Connor Keefe.
Now, beyond yourself, Trooper Keefe and Ms. Vogt, anybody else from the detective unit, as far as troopers, would they have access to these devices, being defendants, Mr. O'Keefe's, Ms. McCabe's, or Ms. Roberts?
If they're in the digital evidence lab, no. Once the data is extracted from them, normally we give them back to the investigator or return to family. So that would be the only time that they would have access to the devices, or unless we kept them in the lab for just for, I don't want to say safekeeping, but just for storage reasons.
Now, with reference to your review of any of the extractions related to any of those 4 devices, at any point in time, did you observe anything in reference to any information being taken off or deleted from any of those devices at any point in time?
No, sir.
Now, with respect to Ms. Reed's device, the defendant's device, it was sometime in August of 2022 that the Gray Key was able to break into the passcode and get into the device, correct?
That's correct.
And so then, once an extraction is done, that's then subsequently reviewed by someone within your unit, is that correct?
Yeah, so again, normally the investigators for the homicides know far more information about the crime and what occurred. So if need be, I'll load the phone up for them. They can go through it because they know what they're looking for. If they ask me, I'm happy to go through. If they can say, you know, I'm looking for calls between this time period, or, you know, GPS locations, things like that.
It's funny how he said normally the lead investigators know know the most about the case and what's like what the details are in the case. Not in this case, because apparently, as he decided, he didn't want to go down so many different avenues to get information on stuff. Anyway.
Now, with reference to the defendant's phone, at some point were you made aware that there was some privileged information contained within her phone?
Yes, I was.
So as a result of that, what, if anything, happened with the phone from there?
We notified our supervisors, and we did not look at her extraction until the privileged communications could be removed, and then we could, again, go back and re-inspect the data.
Now, as far as that whole process that was undertaken in regard to that, how long a time period, or when was it that you were able to have the privileged information extracted and then actually get to look at the defense phone?
It took months. I don't think we got it back from the AG's office until later, springtime of 2023-ish.
Now, with respect to the extraction from each of these four respective devices, that being the defendants, Mr. O'Keefe, Mr. Caves, and Ms. Roberts, what kind of tools were used to conduct those extractions?
Gray key, Windows 10, and then Cellbrite Physical Analyzer and Axiom, their program, Magnets program.
And so as far as, I guess my question is, as far as the different devices that are used, why are there different devices, and what is it that one does versus the other?
So they both do great work with, decoding the data. I've noticed that Axiom does a better job at pulling GPS spots because it gives a speed and a estimated range of how strong the GPS signals are, as opposed to Cellbrite. They give native locations, but they don't have that extra data with it. So I like to look at both tools to make sure that I'm seeing everything that I need to.
Now, with respect to the defendant's phone, you at some points reviewed the extraction from the defendant's phone, correct?
Yes, I did.
And with respect to that phone, what, if anything, did you observe with regard to GPS locations associated with that device?
I didn't see that many, maybe a handful showing different spots in Canton, but nothing that stood out to me.
Now, with respect to your review of the phone, what, if anything, were you able to ascertain as to whether or not those GPS locations were allowed or permitted or turned off or on by you?
I can't say. I didn't see anything, like I said, that stuck out to me. Normally, if the GPS points aren't there, then location services are probably turned off.
What I'm asking, though, is the device itself is capable of retaining that data as far as GPS location, correct?
Yes, if it's turned on.
And there were no real GPS locations to speak of that you observed in your review of the extraction of the defendant, correct?
That's correct.
Now, with regard...
So that is a point of suspicion if she turned off her phone to like turning off the GPS on the phone as opposed to turning off the phone entirely. Her phone wasn't off, it seems like, because otherwise she wouldn't have been pinging around these different cell phone towers, right? If her phone was off, that wouldn't have happened. So, okay, this answer about the GPS is interesting.
To Mr. O'Keefe's phone, what, if anything, were you able to ascertain from that as far as GPS locations were concerned?
There was quite a bit, especially on January 29th.
Now, sir, before we get into that, if I could ask you some questions in regard to Mr. Cave's excuse me, phone extraction. You had occasion to review that, is that correct?
Yes, sir.
And so, in regard to that, also, you had mentioned that you had reviewed an affidavit from a defense expert or defense witness named Mr. Richard Green, correct?
That's correct.
And based on your review of that, what, if anything, based on your review of what Mr. Green said or did, what, if anything, did you then do with regard to Mr. Cave's phone?
So I basically went point by point through his report to confirm or deny if what he was placing in there was true.
And what, if anything, were you able to ascertain or learn from going through Mr. Cave's phone with reference to what Mr. Green stated? Objection.
I'll allow that.
It was mostly incorrect.
And when you say mostly incorrect, what was mostly incorrect?
So he states that there's a Google search that's done at 2:27 in the morning. That immediately stuck out to me because when I went back and looked, that file that was parsed was not from the database that should have showed searches. This came from the session state tabs for Safari. which is a big red flag. It also came from a wall file, which is a dropping ground for where data is put before it's actually put into the main database itself. And then once it reaches a certain point, that data is automatically deleted by the device, not by a user, which Mr. Green had stated that a search was done and then it was purposely deleted. There was also items regarding phone calls being deleted. Again, they came from a wall file. Looking at it, again, it's stored in the knowledge seed, the main database. It's also stored in the biome, showing in the attraction, which is another storage area that Apple is using. Again, nothing, most of the stuff that I was reading in his report was either incorrectly, I don't know, written down, or he's interpreted it incorrectly.
Okay, this is this witness being in here to try to combat the expert testimony about the Celebrate stuff. I'm sorry, like the previous two witnesses were sufficient to do that. Now that they're throwing in this guy, I feel like there's a danger with having him come in. He might end up confusing the jury, because this guy is I don't know. I mean, he has worked quite a bit with phone extractions and data and things like that. But like, I can already tell you right now, I don't think that he is as strong and as technical or technically knowledgeable as the other two. I don't know that this is going to help the prosecution. This may end up backtracking a bit for them. And also, by the way, this is a third witness now for the prosecution to combat an expert witness by the defense on an issue that is not important for them to prove their case in chief. It's fine to do that, but in a case where they are not actually proving their case in chief, they are spending a lot of time on an issue that is like the defense's side. This is the prosecution going on defense against the defense's theory, which is, like, again, fine. It's fine to do that. But before you do that, or I guess in conjunction with doing that, you have to be presenting evidence for your own case in chief, because otherwise you have this serious vulnerability. You're spending so much time on rebutting what the defense said and not enough time on actually presenting your case.
Now, with regard to the phone calls or the contacts that Mr. Green indicated were user deleted or deleted by the user, what, if any, information did you look in regard to that? What, if any, did you ascertain in regard to that?
Yeah, so he stated that Ms. McCabe had deleted 18 phone calls from the morning after John O'Keefe's body was found. Looking at the data from her call log, those calls, while they do show marked as deleted, again, they come from the wall file, and they're also located in two other parts of the database. Again, as a user of an iPhone, you can't go in and just delete these files. They're handled by the operating system. It's impossible.
So as far as what, if any, opinion do you, well, let me ask you this first. As far as a wall of a writing log file, can you explain that, what you understand that term to mean to the jury as it pertains to these particular items?
Yeah, so as I said, these files are dropping ground. So when you're using your apps, using the phone, it takes that data, puts it into this wall file until you either close the app or you shut down the phone, or it reaches a certain number of data in the phone. That wall file will automatically delete from the phone. So this can be on a first in, first out basis. Again, like I said, it could be when data reaches a certain level, but those calls that are being marked as deleted, Celebrate's seeing, it doesn't mean the user deleted them. It just means they're being removed from the wall file.
You indicated that from your review of the phone extraction, there were other areas or other databases, bases, within the phone that contain that same information?
Yes. So the main database of the iPhones is the Knowledge Seed database. They're also using Biome, and then if you're using the newest software now, it's another area I won't bore you with, but
You're already there.
depending on the iOS you're using for the phone, it's going to depend on where that data is being stored.
Now, specifically with respect to Ms. McCabe's phone, one of the contentions Mr. Green had was in regard to a contact for Brian Howard. Is that correct?
Yes, that was another one.
With respect to that, what, if anything, were you able to find within Ms. McCabe's phone in regard to contact information for Brian Howard?
Yeah, so Mr. Green's report said that he located a deleted screenshot of Brian Albert's contact, that was in her phone. The contact for Brian Albert was still in her phone, not deleted. So I don't know, maybe she just deleted the screenshot.
Now, with respect to Ms. McCabe's phone, what, if anything, did you do with regard to the call log history in Ms. McCabe's phone?
I exported it all out to PDF so I could view it. And again, like I said, there's, I think, 1,104 phone calls from going all the way back to October of 2020, I want to say. And phone calls, FaceTime, they're all, the calls are there, all the records, and they're all stored in different areas of the phone. The only ones that show the wall file deleted were the ones from the 29th going up to the end, towards the end of the day on the 29th.
And now, with respect to the call history, where or how is that typically stored within an iOS device?
I believe that's stored in the call stored dash SQLite database.
And with reference to what, if any, difference storage-wise is that SQLite database versus the wall file?
So again, yeah, that database where the call logs are sent, it's going to have a corresponding wall file where the data is going to be put temporarily. And then, as I said, it gets automatically deleted by the iOS, by the operating software. It's not user enabled.
And so from your review of those 1,104 phone call history records containing the extraction of Mr. McCabe's phone, what, if any, opinion do you have in regard to whether or not those items were deleted by any user?
I don't believe they were. And actually, I will say one of the phone calls was from the actual main call stored database. That could have been user deleted but again, it's in two other spots in the operating system. So I don't know how or why the iOS stores it the way it does. And then marks what.
Now, sir, from your review of before phone extractions that you reviewed in this case, were you able to export or print certain chat reports from specific people's phones or between from specific people's phones with other individuals?
Yes, I was able to.
And Your Honor, may I approach?
Yes.
What's been marked as, sir, I'm showing you what's been marked as Exhibit 48.
Okay.
You recognize, excuse me, do you recognize that, sir?
Yes.
And what do you recognize that?
The first page is Facebook Messenger chats between Karen Reed and John O'Keefe.
And what's contained in there, is that a fair and accurate portrayal of what you observed from the extraction from Mr. O'Keefe's phone?
Yes, it is.
And specifically with reference to those chats between Mr. O'Keefe and the defendant, you also reviewed that material from the defendant's phone as well?
Yes, I did.
The material that you reviewed from the defendant's phone, is that consistent with what you observed from Mr. O'Keefe's phone?
Yes, it is.
Your Honor, with court's permission, if I could request.
Wait, John, when you've been talking about this whisper coming up in chat, did you guys hear it? Let me go back. We're gonna. So yeah, that kind of confirms the general attitude that it feels like Lally has about this entire case.
Honor, with the court's permission, if I could request certain portions of what's been marked as Exhibit 48 being published to the jury as we go through them.
Okay.
Sir, if I could just start you out on page 1.
Okay.
Lally is very excited about
Gentlemen, if I could have
prosecuting this case.
Now,
No wonder why I feel like I'm falling asleep, because he's falling asleep. He's miserable right here. So I'm sorry, but like when you are trying a case, you are the one that is going to have like the greatest impact on all of the other people who are trying to follow along. That means the witnesses that are being directed. That means the jury that's trying to listen to parse through all of this.
With respect to what's up on the screen, the portion that you can see, do you recognize this, sir?
Yes, I do.
Now we have before you as Exhibit 48.
Yes.
Now, within this particular, from the perspective of this is from Mr. O'Keefe's phone, is that correct?
Yes, it is.
I predict that these text messages are going to be talking about the January 1st incident where she thought that he was cheating on him. The not Aruba, Bermuda, right? No, it is Aruba. Right? The Aruba incident? I keep mixing them up. Someone in the chat is going to tell me. Yeah, it's Aruba because of the song. Okay, Aruba. I see it in the chat now. Thanks, guys. I think it's going to be about the Aruba incident.
So there will be blue bubbles and green bubbles, is that correct as well?
Yes.
And so who, as far as the blue bubbles are concerned, who is speaking in that?
The blue bubbles will be from Ms. Reed, and the green bubbles are from Officer O'Keefe.
Now, Ms. Gilman, if you could please scroll down. Now, with respect to what's contained on this page 1 at the bottom, if you could read the date and the time and indicate who is speaking and what is said there, sir.
Yeah. So the blue bubble is Karen Reed and 1/28/2022 at 3:30 p.m. Hello. John says hi at 3:35 p.m.
Oh, okay. So it's not about Aruba. This is all on the 28th. What time? Okay, so 3:30, 3:35.
Sorry, may I
Yeah.
approach, John?
Yes.
Yep. Those are the Facebook ones.
I'm sorry. What's contained in Exhibit 48 is the entirety of the chat report from Mr. O'Keefe's phone, correct?
Yes, I believe so.
May I approach, Your Honor?
Yes.
I apologize. Showing you another document. Do you recognize that?
Yes.
What do you recognize that to be, sir?
These are the native chats, native messages from John O'Keefe and Karen Reed.
So these are just specifically broken down as far as the chats between Mr. O'Keefe's phone and Ms. Reed's phone, correct?
Correct.
And as far as your review of both of the extractions from both of those phones, the material contained within Mr. O'Keefe's phone is consistent with the material contained in the defendant's phone, correct?
Yes, that's correct.
Your Honor, may I approach?
Yes.
I want to seek to introduce the witness next exhibit. Okay.
Okay.
So that's 6:20.
627.
Yes. If that could be returned to the witness, Your Honor, if we could, with court's permission, if we could publish that.
Yes. Go right ahead.
And now, Trooper Guarino, do you recognize what's up on the screen as the next exhibit, sir? Ms. Gilman, I'm sorry, if you could scroll down just a little bit.
Yes.
And again, from this first page, if you could, the blue bubble is from Ms. Reed, is that correct?
Yes, that's correct.
Being from Mr. O'Keefe, is that correct?
Yes.
And if you could, again, read from this first page as far as date, time, who is speaking, and what is it?
At 9:49 a.m., Karen says, "You've really hurt me this time." 10:02 a.m., "I'm sorry. This is, sorry, it's kind of read. I'm sorry, this has been an issue with me for 8 years. It physically hurts me to see everyone else in their life do things for them, and I'm forced to always be the bad guy." At 10:09 a.m., Karen says, "I am not the same as everybody else. Most of the time, I try to do what is healthy/smart for them. More importantly, I try to support you and what you need. You just lashed out at me and said terrible things. I don't know how you've gone to this point with me, but I'm just trying my hardest. You made the point. I made your point and continue to beat me down. I have a lot going on too. Physically, I'm falling apart and trying to get answers and help."
If I could stop you there, sir. If I could direct your attention to
Little louder, please, sir.
my apologies. Sir, if I could direct you to page 5.
Okay.
I'm sorry, bottom of page 4.
All right.
And starting with the blue bubble on the bottom of page 4, again, if you could indicate as to who's speaking, what is said, and the date and time.
Karen says to John at 1:21 p.m. on the 28th, "Maybe you can call someone."
Why are these out of order?
Continue on through page 5, sir.
On the 28th at 1:46 p.m., John says, "Like who?" And 1:47 p.m., what time are you coming here? And then there is, at 2:05, there's a message, but no content.
And the next message at 2:06, sir?
Yes, 2:06 from Karen. I don't know what time. Feel kind of out of it. Just trying to clear my head.
These are
2:06 p.m. John writes back, okay. 2:06 p.m. again. Karen says, text me later when you guys settle in later. Oh, sorry, text me when you guys settle in later. John says, sure, at 2:06 p.m. again. Karen says at 2:16, I feel pretty shitty about this. Feel pretty shitty about how this morning went down. I know you said sorry, but it really stung, especially when I've been trying pretty hard lately. I feel like a loser turning around, just coming back over after everything you said.
If I could ask you to continue on to page 7, sir.
Okay. At 2:17 p.m., John says, not sure what else you want me to do. I said I'm sorry and I was out of line. If you prefer to stay home, I totally get it. Karen replies back at 2:17, things in my own life have been difficult too, you know. John writes back at 2:17, I know. At 2:25 p.m., tell me if you're interested in someone else. Can't think of any other reason you've been like this. From Karen.
You could continue on to page 8, sir.
At 2:25, John responds back, nope. Things haven't been great between us for a while. Ever consider that? Those are 2:26. At 2:29, he writes, kids are here, not in the mood to talk.
And how does the defendant respond to that at the bottom of page 8?
So you're not into it anymore. That's fine, but I don't want to keep trying, and you keep treating me like this. At 2:29 p.m.
If I could direct you to the next page 9.
Yep. Ms. Reed says, I'm trying to hug and kiss you this morning, and you whack me in the face with a pillow. At 2:29. At 2:30, she says, last night you're basically like, yeah, what about? When we talk about the future. So why don't you just admit you're not into it so much anymore? At 2:30. Oh, sorry.
Go ahead.
I would say 2:30. John says, not how it went down, but okay.
Now does Ms. Reed respond to that?
Can you please admit your head is out of the game with us?
If you could, sir, please continue on to the top of page 10.
Okay. At 2:32 p.m., sick of always arguing and fighting. It's been weekly for several months now. So yeah, I'm not as quick to jump back into being lovey-dovey as you apparently. From John. And then John again at 2:32. Oh my God, stop calling.
I could stop you there for just a moment, sir. With regard to January 28th, you were also able to extract a report specifically in regard to calls received by Mr. O'Keefe on that date.
Yes, I was.
I mean, on that date into the next date of January 29th.
Yes.
May I approach, Your Honor?
Yes.
Here we go.
'Sorry, we're gonna fast forward.
9th at 6.
Sorry.
Yes, from
Correct.
Again. And
Entirety of the call log from January 28th into 29th, is that correct?
yes, from 20th at 9:19 a.m. to the 29th at 6:03 a.m.
May I approach, Your Honor?
Yes.
I'm also seeking to introduce the next exhibit. No objection.
so, okay, so they were in a fight earlier in the day on the 28th. Looked like maybe they were talking about breaking up. Is that enough for motive for murder?
May I approach, Your Honor?
Yes.
I don't see it.
Another document.
That's just me.
Finish.
January 29th at 12:30.
Sir.
Yes, this is Karen Reed's call log from January 29th at 12:33 a.m. to January 29th at 6:03 a.m.
And those are specifically calls between the defendant and Mr. O'Keefe, correct?
Yes, that is correct.
May I approach again, Your Honor?
Yes.
I'm also seeking to introduce the next exhibit. No objection. Now, Trooper Guarino, from the text messages that you were just testifying from, Mr. O'Keefe indicates OMG stopped calling at 2:32 p.m. Is that correct?
Yes, that is correct.
Now, From your review of those call logs, how many times did the defendant call Mr. O'Keefe on January 28th from approximately 9:19 a.m. to about 2:58 p.m.?
There's 18 calls from 9:19 to about 2:59 p.m.
Those calls are listed within those records as various as far as rejected, or missed, or answered, or things of that nature. Is that correct?
Yes, that is correct.
How many of them are rejected?
11.
How many of them are missed?
4.
And how many are answered?
3.
Now, following that text message at 2:32 p.m.
How many people have been in a relationship where they have started calling their significant other when they're really mad, and like just having an argument, and it's not in person, it's over the phone or what have you, and one side has been calling the other side repeatedly, basically like poking at the other person, like talk to me. I would venture to guess that a lot of people have been through that, both on one side and on the other side of that. Okay, what does that mean? That means you're in a fight where somebody's really mad. Doesn't necessarily mean that leads to murder. And truth be told, I am willing to go with the prosecution on various points where I think it makes sense. So, I'm not blindly pro defense in this particular case, but I don't see this. I don't see this leading to murder. This is a fight that they've had, unless Lally's going to dazzle us with some more information now. That's basically going to be, her saying, if we break up, I'm going to end your life. You know what I mean?
Mr. O'Keefe to the defendant, asking her to stop calling him. Does the defendant keep calling?
Yes, she does.
And at some point, does Mr. O'Keefe call Ms. Reed back?
Yes, at about 3 p.m. on the 28th. Double check.
Thanks. May I approach, Your Honor?
Yes.
Guarino, I can take each of the call logs, but I want you to hold on a second.
Okay.
Now, sir, if I can turn your attention back to page 10 on the text messages with respect.
Okay, so Mr. Lally, when you put your head down and when you walk away, we can't hear you. And so there won't be a record of this. So you have to keep your voice up.
Thank you.
Well, you just said, you just put your head down and your voice went down. So keep your voice up. It's really important you do so.
Trooper Guarino, turning your attention back to page 10 of these text messages, let's read from Ms. Reed's response to Mr. O'Keefe at 2:32.
Yes, so 2:32 p.m. She says, "Why would you start with me this morning?" And then followed up by 2:33, "You're setting me up to fail."
If I could turn your attention to page 11 and ask you to continue from there.
Ms. Reed says, you start a number of fights from your end. John, and that's at 2:33. At 2:33, John writes back, "I've explained it a few times already, not doing it again."
And how does the defendant respond to that?
"So you're not into this anymore." And then John says, "Not into fighting all the time, correct?" That's at 2:34 p.m.
If I could turn your attention to the top of page 12.
So yeah, this does sound like she wants to have a conversation. He doesn't want to have a conversation. That's why she keeps calling him. He keeps avoiding her. And it's like, that's not the healthiest thing for resolving a conflict, but it does sound like this is something that's been an issue for a while. And it sounds like it's related to child rearing and raising kids. So, like, because she mentioned something about spoiling the kids, used to do it a lot more, and she's trying to be better, she's trying to improve. And it sounds like he's got certain standards that he's very strict on. And it sounds to me, based on their conversation, his apology for the way that he was in that earlier conversation, and her kind of like explaining her complaints, it sounds like she doesn't feel like she's been fully heard, or maybe she's still pestering him on an issue that they've already fully discussed. I don't know. But, it sounds like this is a guy who, when he has a criticism, he's going to be very heavy-handed about it. That is what it sounds like. Maybe that's the experience of it, at least subjectively from Karen Reed's perspective. I don't know. But, it does seem like she's trying to have a mature conversation about it. Like, she's explaining from her perspective how she feels and how, she feels that there are certain ways that she's being treated that's not right. I mean, this is just a classic, relationship argument. You did X, I didn't appreciate that. That had Y impact on me.
Yes, 234. Ms. Reed says, if you tell me you're interested in someone else, you will never hear from me again. You can have all the space in the world.
Oof.
John writes back that there's no content at 234. And then at 234, she says, then stop starting with me.
How does Mr. O'Keefe respond to that?
At 234, he writes back, I'm not answering, stop calling.
And if you could, if I could turn your attention.
And that also is like, this is an issue with these kinds of relationships too. When you have one person that is trying to go nearer to talk about an issue, to resolve an issue, and then at the same time signaling to, if you are trying to distance yourself so much because you have someone else that you want to be in a relationship instead of me, tell me. And this person who is on the other end of this conversation, who is not willing to have a conversation, it's like, this is like a cycle that can just kind of continue to feed itself, right? In this kind of a relationship where one side is trying to get closer and the other side instinctively pulls away to have their space, but that pulling away causes that person to want to get closer, and then it causes the other person to want to pull away more. It's like, yeah, this is one of those cycles it sounds like they're caught in, that they don't know how to get out of, perhaps. Or maybe it just looks like that from this particular snapshot of their relationship. Granted, this is a very small time frame that we are seeing in their interaction between them. This is the first time that we're seeing anything concrete of the conversations that she and John O'Keefe had. Maybe there's a time following this that they kiss and make up and they, everything's fine. It's all water under the bridge. Plenty of people go through conversations like this, go through cycles like this, and it doesn't end up in murder. So where does this start to point towards murder?
The top of page 13.
Ms. Reed says, can you please answer after how you treated me earlier? John responds back at 235, Kaylee is right here. Ms. Reed says, you're starting a rage with me out of nowhere, and then you tell me you're sick of fighting with me at 235.
Yeah, that would suck.
She writes at 238, I'm going to grab a drink in a bit.
If I could direct you to the top of page 14, sir.
She says, can you answer please at 238? He writes back at 239, no, Karen, not sure why you need to announce that you're going drinking, but have fun. Karen writes back at 240, seeing if you want to meet me later. Can you please call me right after that?
And again, if I could direct you to the top of page 15.
John writes back at 240, have to take him to the doctor. He has practice. Ms. Reed writes back, yeah, 5 minutes. John writes back at 243, my father just walked in. Aaron writes back, okay, can you please call me for 2 minutes at 244.
The top of page 16, sir.
244, John writes back, not right now. Aaron writes back, I'm there when anyone else needs me at 244. 246, yes, John, you gave me utter grief this morning. I'd like you to call me for a minute.
And the last one from that page, sir.
Yeah, 247, I've been trying to get over the hump with is arguing, and now you tell me you're not into things. And if you don't want to fight weekly, but fly off the handle at 8 a.m. with me, like you're setting me up to fail.
Sir, if I could draw your attention to page 42.
Yeah, that doesn't sound fair. If what she's saying is accurate, right?
And sir, if I could ask you to start reading from the top of page 42.
At 7:41 p.m., Karen writes, okay, let me know if you end up leaving. John writes back at 7:42, why? Now you're not coming? Karen writes back, I'm waiting for the plumber. Actually think he's in the driveway. 7:42. John says 7:43, we're taking Mike's car, so I'm relying on you for a ride home if he leaves. Karen writes back at 7:43, he's not going home after. John writes back at 7:43, 8 on a Friday. He may have to get Michael. And you have a plumber coming over at 8. Knowing me and Papa could have handled it. Good luck. And that was at 7:44.
Okay. But for that response, if she's called him 18 times and he's dismissed it or rejected it at least 15 times, yeah, maybe you're having a plumbing issue and usually your boyfriend or his father help you and he's not responding to any of your phone calls and you decide that you're going to get it done.
direct your attention to page 49.
But you know,
Okay.
they're
If I could ask you to.
in a fight. They're gonna find things to be angry at one another about it. It seems like, and that happens too. It's not the best, but it happens.
Start from page 49, sir.
8:29 p.m. Yeah, but he lives right down the road. John writes back at 8:30. Karen, this storm is going to be intense. Can't drive. 8:30. She writes back, okay, well, if he can't, he can't. John writes back, I'll do it Monday. Karen responds at 8:31. Ha, I better not still have this problem on Monday. John writes back, plan on being there. Karen writes back at 8:32. I'd like to know, I could take a hot shower here if I need to. John writes back, figured you'd be in Canton until Monday.
If I could direct you to the top of next page, 51.
John, I'm getting off my phone.
Okay, so then it this fighting is actually kind of interesting to sort of look at, because he's like, no, I don't want to talk to you, I don't want to fight with you, I don't want to talk to you, I don't want to fight with you. But then he's like, but wait, aren't you going to be here at my house for the whole weekend during the snowstorm? So you know, the logic or illogic of these text messages during this fight, we can't really take this too seriously, is my conclusion. This is a couple that is arguing in a way that couples argue. It doesn't always make sense. So we can't put so much weight into the things that are said here to be like, oh, they were about to break up. I mean, maybe not though.
Let me know what you're doing. Karen writes back at 8:33. I think the four of us together is toxic to this relationship. Would like to limit it. And then says, you've said so yourself for probably a year now. And John writes back at 8:33. Blizzard tomorrow. Nobody is going anywhere.
Sir, if I could direct you to the top of page 52.
Okay. Karen says, maybe I'll come back late tonight. Bad snow is in the early AM. That's at 8:35. And again, 8:35. I'll head up there in a few minutes. Let me know if you leave. John replies back, sure. And then the next one's not until 12:55 in AM on the 29th. I'm going home.
And the I'm going home is from the defendant, 12:55 a.m. Is that correct?
Yes, that is correct.
And if I could direct your attention to the top of page 53.
Yes, at 12:55 again. See you later. At 1:02, your kids are cucking alone. 1:29, at 1:04 a.m. I'm back in Mansfield. The kids are home alone.
Thank you, sir. Madam Mayor, approach the
This also, oh my gosh, you guys, this is not helpful to the prosecution, because this also explains how she got wound up so quickly that next morning. Like you look back at these texts. So 12:55 a.m. I'm going home. I think that what she's talking about is her home. She's been waiting around for him after he was like, well, I thought you were going to spend the weekend in Canton with me. And so she says, you know, I'm going home at 12:55 because he's not there. And then.
Correct.
Yes, that is correct.
And if I could direct your attention to the top of page 53.
Okay.
Yes, at 12:55 again. See you later. At 1:02, your kids are cucking alone. 1:29, 1:04 a.m. I'm back in Mansfield. The kids are home alone.
Which doesn't seem to be correct, because she didn't actually leave Canton for Mansfield at that time. But she's trying to pull the, like, I'm walking away. You better look. You better come get me. You know, that kind of thing. So this is her already being upset and already being kind of triggered with like him not responding. That started on the 28th. So him not responding at 1:04 a.m. is already upsetting. And then what happens if it's 2 a.m., 3 a.m., 4 a.m., you know, and then of course, 4:30, she starts calling other people, because now she's probably wound herself up so much that she's, you know, freaking out about him actually being out in the storm. So yeah, I can, this, for me personally, this tells me how she got wound up so quickly, so early in the morning there. Yeah. Travis James, she's trying to get his attention. That's exactly what it is. And that's what she's been trying to do that entire day, it seems like, on the 28th. So there's tensions that have not quite been let up. And now this happens.
Thank you, sir. Madam Mayor, approach to retrieve.
Yes. Can I see counsel at sidebar about scheduling?
You are
Okay. Sidebar. Does this mean we're ending for the day?
Scheduling.
Oops.
With this witness, but can we go until 4:15? I know it's been a long day, but does that work for you all?
All right, thank you very much. So why don't we do that, and then I'll talk to you about scheduling after.
you are unmuted.
May I have one moment?
Yes.
May I approach this?
Yes.
Now, Trooper Guarino, you were also able to get some chats as well as some phone calls between the defendant and certain individuals. Is that correct?
Yes.
And may I approach her?
Yes.
Okay, guys, a couple more minutes in the poll, and then I'm going to change over to the conspiracy poll.
So I'm showing you two documents. Just have to review those.
Okay. Okay.
And do you recognize those, sir?
Yes, I do.
And what do you recognize those to be?
The single page is Karen Reed to Laura Sullivan phone calls, or I should say, yep, calls from Laura Sullivan to Karen Reed. And the other one is Karen Reed and Laura Sullivan's chat messages.
What's contained in those documents, is that a fair and accurate portrayal of what you were able to extract from the defendant's phone?
Yes, sir.
May I approach again, Your Honor?
Yes.
I'm on the seat to introduce the minutes and next exhibits. No objection.
Okay.
No. May I approach, Your Honor?
Yes.
Recognize
Phone call. Yes, these are Karen Reed and Erin O'Keefe phone call.
And what is contained in that, is that a fair and accurate portrayal of what you observed conducting the extraction of the defendant's phone with regard to the communications with Erin O'Keefe?
Yes.
May I approach again, Your Honor?
Yes.
I want to introduce the minutes and next exhibit.
Okay. There's no objection, Mr. Yannetti, right?
So Erin O'Keefe, I think that's the sister-in-law.
No objection. May I-
6:32.
I'm very sorry, Madam Clerk. Your Honor, may I approach the witness?
Yes.
I'm showing you what's previously been marked as exhibits 51 and 52. You recognize those?
Yes, these are phone calls between Karen Reed and Katie Camerano. And 52 is chats between Karen Reed and Katie Camerano.
May I approach this to retrieve, Your Honor?
Yes.
What's contained in those exhibits 51 and 52, is that a fair and accurate portrayal of what you observed during the extraction of the material from the defendant's phone?
Yes.
Another thing, by the way, with those text messages at 12:55, 1:04 a.m., that would have been like, if we're to take those texts and put them in the context of the prosecution's argument, if we're to accept the argument that she actually hit him, what would be the purpose in her sending those text messages at 12:55 or 1:04 a.m. to him? Like, she's going to pretend like she's still fighting with him? Because to me, those look like sincere phone calls. Like, she's upset that he's not responding. She's upset that he's not, that, like, you know, he hasn't come home yet. And yet she's spending time away from her own home to take care of his kids, to make sure his kids are being watched while he's out partying with other people. Like, that's, I don't understand how they explain that, because to me, those look like sincere, real text messages. Like, she's actually still angry. So why would she send those at that hour if she hit him?
May I approach again, Your Honor?
Yes.
Sir, showing you what's marked as exhibits 94 and then 95.
Yes, I'm sorry. They are chats between Karen Reed and Jen McCabe, text messages, and 95 is Karen Reed and Jen McCabe phone calls.
And again, what's contained in those records before you is that a fair and accurate portrayal of what you observed in the defendant's phone during the course of your extraction of materials from her phone.
Yes.
I approach the retrieve, Your Honor.
Yes.
So these are already in evidence, Mr. Lally, so that you don't need the fair and accurate depiction.
I approach again, Your Honor.
Yes. I'm going to send you home.
Oh.
Jurors, you know what? I'm going to send you home.
Okay, so I need to see counsel at sidebar for just a minute to figure out the next 2 days.
Okay.
You are muted.
What I want to know is whether this voir dire tomorrow is going to be televised. That's what I need to know, because I imagine folks will want to watch that if it is televised. But if not, I would like to know how I can organize my day. Okay. We're now like 5 minutes.
So, or
behind.
read about
Oops.
it. Won't be, all right?
Okay.
So jurors, we will
You
be
are
in session
unmuted.
tomorrow, but you won't be, all right? So it's very important that you don't watch TV or listen to anything, or read about anything. So we will be here tomorrow. Wednesday is the federal holiday, so we're not in session. I know there's supposed to be some big heat wave this week. I really appreciate that everybody dresses respectfully for court. I suggest you come in comfortably. It's an old building. The air conditioning's been great today. I don't know that that will hold up when really pushed. So feel free to dress comfortably. We'll plan on seeing you on Thursday. If that changes, the court officers have your contact information, but we're planning on seeing you on Thursday. All right, so please, those 3 cautions: do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it. Let us know. We'll see you Thursday morning.
All rise for the court, please.
Okay. So jury is not in until Thursday. Tuesday is the voir dire. We need to know, for our purposes, if that's going to be televised. I don't think she's going to say anything in the courtroom about it. We'll probably have to find out from one of the journalists.
Okay, thank you.
All right. All right. So we'll fast forward probably until the very end. I don't think there's going to be anything else. Okay. And that is the end of the day. Okay. Okay. John O'Rourke, thank you so much for the super chat. You're classy, quote unquote. I appreciate the quotations there because it suggests maybe not. No, I'm kidding. And have never been in a hoochie mama crisis. All people go through difficulties like such, but something shifty things happened. Unfortunately, accident happened, blah. Yeah, I mean, it seems to me like they were in the middle of an argument when all of this went down. And I think that her text messages around 12:55, 104, those suggest that she still was in the argument. That doesn't quite fit with this idea that she killed him, that she hit him with her car some 20 minutes before that, or even 15 minutes before that. So, okay. Let me get through some questions here. We've got a few, not too many. And then we will wrap it up for the day. And I will put out a post about whether or not there's anything for, what's it called? For voir dire for tomorrow. Because tomorrow there's supposed to be at least one expert witness is going to go through voir dire. So we'll see. If there is not anything, I'll be working on other content. But if there is, then we will be live here same time as usual with my actual calculations that are correct for the time zones. All right, let's get these questions, shall we? Spunky Nuggets, Legalbytes. What, if any, poll will you put up regarding the conspiracy? Let me do that right now. I know I keep forgetting. Okay, so I'm going to end this poll now. First, halfway through day 26, how do you lean regarding KR's murder charge? Not guilty, 85%. Need more information, 8%. Guilty, 5%. This is 1,200 votes. So, all right. That's interesting. Okay, let me type up another poll really quick. So we'll do this just for the end of the stream while I go through other questions. So just give me a moment, talk amongst yourselves. Okay, here is the poll. All right. Do you believe the defense's theory of a conspiracy to frame? I went away from me. Theory to frame. Okay, sorry. Let me start it again. Do you believe the defense's theory of a conspiracy to frame KR? Yes. Everyone was involved. Yes. The police did it only. Yes. Alberts, McCabe's, Proctor's only, or not one bit. So we'll take a look at all of those. So far, right now, looking at it, we've got in the lead, 57, 58% is yes, Alberts and McCabe's and Proctor's only. Interesting. Okay, we're going to keep that up for a little bit. Folks keep going ahead and voting. And there we go. Okay. Doctor Who 8675309 Legalbytes feels like prosecution is in the bottom of the eighth, down 15-0, and finally scored a run to make it 15-1 with today. Sure, it breaks the shutout, but the game is still out of hand. That's how I felt at the end of day 25, and certainly today as well. And the thing is, like 15-1, it's like it's actually a better metaphor if we have like two separate games running. Right? Because we have the game that is the defense's theory, and then we have the game that is the prosecution's theory. And in order for the defense to win, they can win on either one. But the prosecution kind of has to win on both, essentially. Right? Because if the jury adopts the defense's theory, then the prosecution loses. But also, the prosecution loses if the jury doesn't adopt the defense's theory, but also doesn't adopt the prosecution's theory. There is a universe in this case where the jury can, at the end of the day, conclude, I don't believe that she was framed, but I also don't believe that there's enough evidence here to convict her. I don't believe that the prosecution has shown me how she supposedly hit him, how she supposedly killed him, how a motor vehicle explains his injuries, how the motor vehicle in this specific instance explains how this crime scene ended up looking the way that it did. If they have questions like that at the end of the day, then the prosecution has not met their burden of proof to prove beyond reasonable doubt that she murdered him. So that's, for me personally, there are aspects of this that feel a little framey from the police, particularly Trooper Proctor. But that could also be that he didn't necessarily have an idea that he was going to frame her, but he just made a very, very hasty decision, and that impacted the rest of this investigation. And it could also be that the Alberts and McCabe's are terrible people, and that they didn't like Karen, and that they were happy to jump onto this conclusion that she killed him because they didn't like her. Like, there are multiple things that could be happening at the same time from these various perspectives. But to me, I don't know that I see enough, especially with like the Google thing. I feel pretty confident, or I feel pretty comfortable with the conclusion at this point. Defense can definitely come back and have their expert witness convince me otherwise. But at this point, from what I heard, particularly from Jessica Hyde's testimony, I'm comfortable with the idea that Jen McCabe did not actually make that Google search at 2:27 a.m. There's been a lot of shadiness. There's been a lot of weirdness, like Jen McCabe's meeting with Officer Lank's wife the next day with Carrie Roberts, whom she had just met. And somehow Jen McCabe is like jumping in the car with Carrie Roberts when she's dropping her kids off to Officer Lank's house. Like, what business does she have with that? They just met each other. There's like things like that are just weird in this case. That make me really question all of these other individuals. But, and then of course I see that in the chat, Heather asked, but without framing, how do you explain away that the taillight pieces at the scene unless the car hit something? I mean, that's the other thing. That's the other thing that looks incredibly suspicious, is the fact that those taillight pieces just slowly show up, and they show up in these weird places that then also get ignored by the accident reconstructionist. But the thing is, like if you don't feel like you have enough information to be able to like really say, okay, yes, I feel comfortable, putting my flag on this hill and saying, yes, she was framed, whether that was by Trooper Proctor or anyone else. I think that if we're looking at likelihoods in terms of like the evidence that we have, to me, it seems like the most likely person to have framed her, if anyone, if anyone, would be Trooper Proctor, because the issues with the taillight pieces are just, those things do not add up. Those don't make sense. So I take particular issue with how all of that showed up. There's just too many questions there to be able to really rely on it. But at the very least, you can say, I don't know if Trooper Proctor was trying to frame her, but I do know that he did a really terrible investigation, and that impacted everything else. And that, as a result, I can't hang my hat on anything that the accident reconstructionist for the prosecution said, any of his conclusions, because it's all based on garbage information. His analysis was also garbage on top of that, in my opinion. But, it's just, yeah. The wins that the defense has been, or the win that the prosecution recently got with this Google search is a very, very small win in what they need in order to secure a conviction. Billy's Momzilla, thanks so much for the super chat. I think Karen was a lucky convenience when waking up worried about John, then the pieces were put in place. I think that's also a possibility. That is definitely a distinct possibility here in this case. Doctor Who 8675309 feels like prosecution is, oh, sorry. Oh, I just got that one. KBH. Oh, I love that. I love your profile picture with the cat toe beans. Do you think the jury is frustrated with the length of time the prosecution is taking and has possibly tuned out? I know I am having difficulty staying engaged. It could be. That can happen too. That's also a serious risk that the prosecution has been running throughout this trial. It has been 2 months of the prosecution putting this case on. And if they're feeling like you keep putting stuff on and it ends up not mattering, they can end up saying, okay, this next person that's coming up is not going to tell me anything different, right? Ashley Roman, what are your baseline thoughts on the jury being 9 women, 6 men? Think defense hoped for more women who would sympathize with KR. What jury makeup would you want? I think that women unfortunately tend to judge women much more harshly than men do. So having more women as a default isn't necessarily better. It can be, but not necessarily better. However, in this particular case, I think the addition of Trooper Proctor's text messages definitely has the ability to inflame a lot of women and unite a lot of women together. Because that's the thing, is that, women can be each other's biggest critic. Case in point, Jen McCabe, her talking about Carrie Roberts, her BFF that she just met. And then also the way that she talks about just other people in general. But maybe she's just a hypercritical person in general. But women do tend to be very critical, more critical of one another than men are of women, in my opinion. That's my personal opinion. Other people might disagree. But I think that women can also unite when they feel like something really wrong is happening. So in this kind of a case, this is one of those situations where they might actually not judge Karen Read more harshly, and they might actually look to their own experiences and say, like, I've been through this, or I've been through that, or that's absolutely not right. And I would hate to have an investigator be going through my phone and looking for nude pics of me and talking like this about me to all of his best friends when, he's supposed to be maintaining a confidential investigation, and he's supposed to be a dispassionate, unbiased investigator who's just trying to figure out which way is up and which way is down. So yeah, that can also happen. Debbie Faison Cook, did you get a PO box set up? I did not have time to do it, unfortunately. Between the trial and trying to balance family time and trial time, that didn't happen. However, I'm going to try to get a PO box set up, some kind of a forwarding sort of situation. I'm going to try to get that figured out remotely. Suki London, Legalbytes, this witness talking about Mr. Green's testimony is rebuttal, isn't it? That witness hasn't testified yet. And I think there is another one that's similar. Travis James, shouldn't Lally wait until the defense witness testifies? No, because the prosecution, they know what kind of issues are going to be coming up on defense. And so they have every right to be able to put a witness on that is going to be anticipating that other testimony. And when we're talking about expert witnesses are also, they are able to, so expert witnesses are also able to observe the testimony of other witnesses. They're also able to read other experts' reports. They are also able to go into other evidence and other data that a normal lay witness cannot. This is one of the reasons why it's a really important thing to be able to designate someone either as an expert or as a lay witness. So because they have the ability to pull from all this kind of information in order to inform their opinion. So part of that, when it comes to expert witnesses, is you also have this battle of the experts, right? Where they are not only trying to convince the jury that what they're saying is correct, but then also saying that what the other expert is saying is wrong. And so they have to kind of give an explanation as to why that is. So that means that, with the prosecution here putting on their experts, they're going to be referring to what the other expert says or what the other expert argues. And that's because the expert is going to be testifying basically what's in the report, and they had that in advance. So they're able to look at that. They're able to formulate their own opinions. They're able to testify about it. So the fact that he hasn't testified yet doesn't mean that they then have to come back after the defense expert testifies. They can talk about it before he even gets up there. That's one of the advantages to being on the prosecution side, is you get to go first, and you can also kind of like try to sort of, I don't know, like spoil the well before they get there, or kind of set the foundation of what the jury might expect from them. So it's not improper at all to do that. Debbie Fizan Cook, can the defense object to a witness as cumulative? Yeah, they can, but that's not going to happen while that witness is on the stand. They're going to do that in advance before they're actually called up. But I will say that the side that's calling that particular witness, in this case, the prosecution, they're going to make some kind of an argument as to, what is different about this person and, how they give some sort of a different angle. Maybe they corroborate. So there is some leeway on that kind of an argument too. Tish, Legalbytes, do we know if they have to find her guilty of intentional murder, or is it enough if they found that she ended him regardless of intent? Not regardless of intent. I think that if I remember correctly, it's recklessness or purposeful. So it could be that she knew that there was a likelihood that she was increasing a certain risk by doing something, by engaging in some kind of behavior, that she willingly disregarded that risk, or willingly disregarded the disregarded the fact that she was causing that risk and just continued to do it anyway. Roy Woodward, the prosecution has persisted long after it should have in the face of malfeasance. That is conspiratorial, and the DA's behavior is questionable at best. Maybe. I mean, I know a lot of people feel, excuse me, sorry. I know a lot of people feel that way. Jet lag is getting to me. We're almost finished here. 40 Doherty, doesn't having rebuttal witnesses now give the defense a leg up though? They know what would be challenged and can get ahead of it. They knew, but at the same time, the defense also knew what the prosecution was going to be arguing in their, with their expert witnesses also, because they also had the reports from their witnesses. So it's like they all kind of know what the other side is going to say in advance of this, regardless of who goes up first. So, yeah. So I don't know. I don't know how much of a leg up it gives. There are ways of going about it, strategizing your positioning, with all of that in mind. LK Ryden, women do judge women more harshly. It's biopsychology. We're very territorial when it comes to the pack. Our biopsychological role in protection. Sorry for speaking of us like we're aliens. No, that makes perfect sense. Life on makeup. Question, to me, it seems that Lally values quantity over quality to the detriment of his case. Do you agree? I think I would agree. I would definitely agree. Okay, folks. That is about it. So let's get this poll here on the conspiracy theory. We've got a little over 500 votes. Also, actually, before we do that, if you are enjoying the stream, please do like it before you do anything else. It really does help to push this out to the algorithm, so that more people can see these streams. They can join us. They can join the chat and engage in everything and have more conversation with everyone on this, whether it is live in the chat or on replay. Liking the video does really, really help. And if you're really, really enjoying it and you want to support the channel, the best way to do that is by becoming a member of Byte Club, either through YouTube memberships or through Patreon. To be a supporter on Patreon, links are in the description below. Also, there's a join button for YouTube memberships as well. There are a number of member benefits, to include members only live stream on Fridays at 10 a.m. East Coast time. Sometimes it gets shifted by things like trial, but usually I try to keep to that. Early access to uploads that are not during a trial, during normal times, things like that. We've got a number of benefits for you there related to membership in Byte Club. But membership really, really does help to keep the lights on and make sure that I can continue to devote all this time and all these resources to topics like this. So, but like I've said before, number one way, if you're not in the, you're not able to join Byte Club right now or at whatever time, liking the video is the best way to do it, because more people see it, then we get AdSense from it. That also helps the channel. So, and also, has 01. Thank you all for joining us today. Don't forget to like the stream, subscribe and ring the bell so you don't miss a video, and it helps Alita on her journey to 250K subscribers. Absolutely. Thank you so much. And yeah, road to 250. We are almost there. Let me see. Still under 246,000 subs, but we must be like right under there. Let me see on the back end here. Where are we at? Okay, 245, 725. So, but we are making our way up there. So hopefully we can get to 250 before the end of this trial. And let's see here. Oh, one more question from Shelley's Flowers. Are you surprised that this information is coming in so late in the trial? I'm surprised by a lot of Lally's decisions in this trial and how he strategizes, the way that he's been putting this information on. I don't quite understand his thinking and his strategy on a lot of these things. So yeah, I guess basically, yeah, I am a little surprised. Janet G. So we don't know yet if tomorrow is on camera. I think Court TV has a feed up. Court TV has a feed scheduled for tomorrow starting at 8 a.m. East Coast time. So I think there probably will be one. They are calling it day 27. I feel like day 27 should be testimony, would be the next day. Anyway, whatever. We'll figure it out. So it does look like there probably will be voir dire tomorrow, live stream tomorrow. I think it's supposed to be a half day. We'll see. But regardless, we'll be here if the feed is up. And I will be putting out some social media on that. Okay, people, folks, people. All right, guys. I better check out. That jet lag, like I said, is really hitting me at this point. Thank you so much for joining me, guys. This has been a great stream. Interesting day. Some hits, some misses for the prosecution. For me, mostly misses, but we'll see. Thanks for joining me. Thanks for all the super chats, for memberships, all that kind of stuff. And we're going to end the poll as well. Thank you for the reminder. And 51% said, yes, I believe in the defense's theory of a conspiracy to frame KR with the Alberts, the McCabe's, and the Proctors only. 31% said everyone was involved. 10% said the police did it only. 6% said, I don't believe in it at all. And that was 585 votes. So interesting. All right. Okay, guys. That for me about does it. Thanks, of course, also to the mods. I always want to make sure I thank them for helping out with making sure the chat, the community is a great place for people to come in and engage. Okay. All right. That about does it. I'll see you guys for the next one. See ya.